Thank you and welcome to the public hearing for the inquiry into budget estimates 2021-2022. Before I commence, I'd like to acknowledge the Gadigal people who are the traditional custodians of this land. I'd like to also pay respect to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginal people present. I welcome Minister Rob Stokes and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for the portfolio of planning and public spaces. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. Today's proceedings are being broadcast live from Parliament's website and a transcript will be placed on the committee's website once it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. All witnesses in budget estimates have a right to procedural fairness according to the procedural fairness resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. If witnesses wish to hand up documents, they should do so through the committee staff. Minister, I remind you and the officers accompanying you that you are free to pass notes and refer directly to your advisor seated at the table behind you. In terms of the audibility of the hearing today, we have witnesses in person and via video conference. Can I ask committee members to clearly identify who questions are directed to, and could I ask everyone appearing remotely to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking? Finally, could everyone please turn their mobile phones to silent for the duration of the hearing? All witnesses will be sworn prior to giving evidence. Minister Stokes, I remind you that of course you do not need to be sworn as you've already sworn an oath to your office as a Member of Parliament. For all witnesses, I ask you in turn, and we'll start with Ms Fishburn, who is in the room with us today. Can you please state your full name, position, title and agency and swear either an oath or an affirmation, and then I will proceed according to the hearing schedule in that order to swear people in. So Ms Fishburn.
Thank you very much. Kirsten Emma Fishburn, Acting Secretary, Department Planning, Industry and Environment, and I will take an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Ms Alex O'Mara.
Alexandra O'Mara. I'm the Group Deputy Secretary of Place Design and
Alex Mara? Yes, Alex Mara. She's quite
in the Department of Planning, Industry and So I'm getting a lot of feedback.
Yes, okay, is that what's happening? Because you're dropping in and out. We'll just look at that. I'll just remind everybody to mute who is tuning in and who are tuning in, sorry, and we'll see if that helps. If you could just continue, Ms O'Mara.
Yeah, I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. Help me God.
It sounded like you were still getting feedback. Is that right?
Yeah.
Just wanted to check that you don't have any other windows open with the hearing or anything. Just check on that as well, that you haven't dialed in twice. We'll continue. That is often the situation. We'll continue, Mr Marcus Ray. We'll see how we go.
Thanks, Chair. Marcus Ray. I'm the Group Deputy Secretary of Planning and Assessment at the Department of Planning, Industry and Environment. And I too am getting some feedback. And I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but.
Okay, thank you. We're working on the tech issues as we speak. I think we're identifying the issues, so apologies for that. Mr John Brogden, we'll keep going.
John Gilbert Brogden. I'm the Chief Executive Officer of Landcom. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. And Mr Brett Whitworth.
Yes, Brett Christopher Whitworth. am the Deputy Secretary, Greater Sydney Place and Infrastructure, and I will make an affirmation. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Mr Whitworth, can I just check, did you have feedback then?
Yes, I did.
Okay, all right, we'll continue trying to find out what the issue is there. Today's hearing, in terms of time, will be conducted from 2 p.m. to 5:15 p.m. with the Minister and departmental witnesses with questions from the opposition and crossbench members only. If required, an additional 15 minutes is allocated at the end for government questions, and we'll aim to have a short 10 to 15 minute break at 3:30 as well. As there's no provision for any witness to make an opening statement before the committee commences, we will commence with questions from the opposition. Ms Penny Sharp.
Thank you, Minister. Thank you to your officials for coming along today. I wanted to ask you about the Greater Sydney Parklands Exposure Bill and your plans for managing parklands across Sydney. And look, my first question is, it seems to me that public open spaces need public funding to actually be able to thrive and survive. I'm concerned that within the Greater Sydney Parklands Exposure Bill that there's too much reliance on private revenue to actually fund the care of these public spaces. Are you able to tell the committee what modelling there is in relation to the amount of revenue generated under this bill that Parklands would be able to achieve?
I'll take part of that on notice, just to say that the focus of this bill is not on raising revenue from parks. Instead, it's about the better management of parks and actually saving money in unnecessary management costs so we can reinvest money in great capital works and activation. Really, the focus of allowing any sort of commercial style activities would be limited to those areas already indicated as such in existing plans of management, where there wouldn't be any adverse impact on environmental heritage or recreation values of those parks. But it's more about providing activation for areas of parks where, for example, a cafe or a gallery might offer more opportunities for the public to have access and use of parklands that currently don't have a great purpose or might be locked off from public access. So it's more an exercise in providing opportunities for activation than anything else. This was certainly not in any way intended as a commercial play. And in fact, the Greater Sydney Parklands, I think, invest about $65 million in capital works across the parks estate. In Callan Park, for example, $14 million is being invested in some great capital works informed by a landscape master plan for that amazing 60-hectare site, of which the preponderance is now looked after by Greater Sydney Parklands. There's still quite a bit that's owned by Health that we'd love to get hold of over time. But effectively, the bill is about improving the management so that we can improve public access to our existing parklands and have a strategic overview of how to better link them together and acquire more.
Thanks, Minister. I mean, within the bill, it doesn't appear to me that there's a limit on the amount of space or type of operation or activity that the parklands could be leased for. How do you think that would be managed?
Well, again, any commercial activities would be limited to areas where already indicated for such on plans of management.
Isn't it the case, though, Minister, that the Minister can alter the plans of management?
Only through the appropriate process, so there would be full public consultation in those processes. But I want to say again that this was not informed, and I'm happy to the extent to find if there is any such information, but I'm not aware of any. It was not informed by financial modelling about how the parks could be commercialised. It was actually the opposite. We're actually seeking to find a model that works better so that we can save money on unnecessary back office sort of activities so that all that money can be reinvested into great activation of parklands. A good example would be, for example, already since the GSP has been functionally created, not legislatively created, but functionally, there's been a security contract, for example, has been able to be brought together for both Centennial Park and Callan Park, which has saved from from something like 50,000 or so just in that one contract alone. So there's huge savings that can be made, as you can imagine, once you can start to link up procurement for all sorts of maintenance activities. These things cost a huge amount of money, and if we can do that as effectively and seamlessly in an integrated way, that liberates more funds to do more exciting things about restoration. We've got a huge restoration challenge ahead of us, particularly in Callan Park, and obviously that'll be funded. And sure, a huge focus of
Sorry,
that.
Minister, you're just saying that all of the restoration work in Callan Park is going to be funded? How's that going to be funded?
Well, no. See, this is the challenge, isn't it? The existing legislative regime has failed. I mean, we've had 20 years to see if it would work in terms of activating all those amazing heritage structures on the park. It hasn't worked. So my plea to the Inner West Council is, guys, let's think of something that might be able to work more effectively. And certainly, if there are other ideas, I mean, we've gone through a green paper, white paper, exposure draft process, and now it'll go through a parliamentary process.
The problem we've got is that what I'm being told, and what many community organisations are saying, is that they actually thought they went through the green paper and the white paper process in good faith, and they believe that the exposure draft doesn't actually really respond to their concerns, and obviously commercialisation, privatisation of however you want to call it, of public space is a really key concern for them. I mean, they're particularly worried about the leasing arrangements where you can have these long-term leases where really there's not a lot of transparency about those. I mean, how do you believe that's going to be protected, given it's not explicit in the exposure draft?
Well, no, there's a couple of things, and certainly, I mean, my door has always been open in terms of legislative amendments that could clarify these things or make them, work better. But a couple of things. You use the word privatisation. This bill explicitly rules out privatisation of any of these parklands, and there are legislative
99-year private leases, Minister. You and I will have to disagree about whether that's privatisation or not.
Well, that's allowed under the existing legislation in relation to legislation passed by a Labor government, which I thought was great legislation, but it facilitated 99-year leases in relation to Western Sydney parklands, and that's proved amazing in terms of funding all sorts of great restoration works, planting thousands of trees and putting in great new trails and, community activation for the communities of Western Sydney. And similarly in Centennial Park, these provisions are already there, so there's nothing new in that sense. But there are gaps in legislation that could allow land that had been acquired to be sold. This will clarify that cannot be done. And in relation to leases, there are some significant protections in relation to community involvement in leases. There is the involvement of the community trustee boards in vetting these processes, and ultimately there is a ministerial process in relation to Callan Park.
They say vetting, they don't have a right of veto though, do they?
That's ultimately, as at present, a matter for the minister. That's appropriate in a democracy, but it has to be done through proper process of transparency. And again, it has to go through legislative processes, and there are opportunities for members, if they want to talk about amendments, I'd be more than happy to look. This is my genuine feel on this is there's an opportunity to fix up a system that's not working effectively. That's something we should be engaged in collaboratively, and I'd love to discuss these things and see how we could make, if there are practical and feasible changes we can make to make this legislation work even better, I'm all ears.
How do you see the lease process working? I mean, I'm trying to, will there be a master plan where there are areas identified and expressions of interest, or will you deal with unsolicited proposals? How do the checks and balances work through? How do you see that working?
Well, I mean, I can. Before I go through, I don't have a copy of the exposure draft in front of me. I might actually seek some assistance here, because we're going into a level of specification, probably through the Secretary to Alex, I'm guessing.
Yes, to Ms O'Mara, thank you.
Yeah, and Ms O'Mara, the question for me really is, how are you going to deal with unsolicited proposals, given I assume that there's actually supposedly going to be areas identified and, they'd be subject to some sort of expression of interest process?
Thank you, Ms Sharp. Can you hear me?
Yes.
Yep.
Hopefully you're not getting feedback.
I am getting feedback, but that's okay. The commercial development under the bill can't be going to be on areas where there are business activities or plans of management. And Any US entity does this in the usual way, under the DPI. But what the bill is putting in place.
Yeah, no, I'm sorry, Ms O'Mara. That's okay. I might have to move on. I think we're struggling to hear you, but thank you.
We'll take that on notice.
Yes, thank you.
Yeah.
That would be very useful. I mean, one of the things that, where are the red lines in terms of development of the parks? Is there going to be, construction, of large stadiums, for example, or indoor sporting or entertainment facilities in the middle of parks? Where are the red lines in terms of what's not going to be allowed under this proposal?
I'm sorry, I don't have a copy of the legislation. I thought I had bought one. But what I can say off the top of my head, I mean, the first thing I'd draw people's attention to is the objectives of the Act itself and of the parks and the objects that are set out there. Obviously, any proposal that was inimical to these objects would not be authorised, and that talks about...
Who decides whether it's the minister that decides, isn't it?
It'd be a matter of statutory interpretation. I couldn't, exceed the powers of the Act so clearly. And we did agonise in terms of these objectives to set out that these parklands, their absolute focus is on public recreation and creating opportunities for public recreation. Unfortunately, I don't have a copy of the Act. I thought I'd brought one along, so I can't take you to the specific
Minister, I'm surprised you haven't memorised it, given your knowledge of the EP&A Act. I thought you'd know this one well.
Well, it changes around.
I'm not going to mark you down today for that.
But the view is we've been changing it around a bit on the basis of listening to the community. I mean, just the other day there was an issue that was raised by the Inner West Council, and we reflected on it related to processes for forming new public roads through parks, and we thought, well, that's a good point, and so we changed the Act on the basis, or the draft on the basis of that feedback. So this is genuinely, we are just trying to come up with something that works really well.
Sure. Minister, aren't you, though, got a lot of trouble when, councils everywhere are basically starting to reject the draft? Do you think these issues are going to be able to be overcome?
Well, there is always... I've learnt there are always, more conservative voices that don't want any change on anything, but that's not a reason for not trying to put forward great public policy ideas to make the world a better place, and that's ultimately the business we're engaged in Parliament. Sorry, I've got a copy of the Act now. But again, my focus has been, if councils have particular concerns or want to get more involved, my door's open to their concerns. But I need to stress as well, this is bigger than any one particular park, and I think there can be a little bit of the of a sense of trying to exclude others from a park. The idea with all these parks, they belong to all of us, and they should be accessible to everybody. And some voices said, for example, in Callan Park that people on the community trustee board should be limited to only people who live in Balmain or Rozelle or within a certain area of the park. These sorts of ideas. I just think the idea here is that we're a city in a park rather than a city with parks, and that the people of Western Sydney, the people of Eastern Sydney, the people of the North, the South, all have the same rights to access and use these parks because they're public assets for everyone in the community to enjoy, and we need more of them.
Thanks, Minister. The issue here, though, really, the great deal of misapprehension from the community in relation to this is a lot of this is the role of the community trust boards, and that they're really, they're not true trust boards in that they'd have oversight and management. It seems to me to be very much a consultation and advice situation. How do you propose to actually deal with that issue? The great concern here is that you're going to have a group of people who are very passionate about the public spaces, as you've identified, in the areas that they live in, as they should be, as everyone is. And they, at the moment, I think they believe that they have more input into the way in which these areas are managed. Their concern is that essentially it's being handed over and there'll be far more ministerial control than there is otherwise. How do you guarantee actual influence or input with the community trust boards? Or I'm concerned that they're just at community advisory committees, and that's why people are so upset.
Well, so I'll draw you to the relevant clause is clause 38 of the exposure draft, talking about the functions of the committees, and their constitution is dealt with in clause 37, talking about their membership.
Yep.
And the idea is effectively they're more the representative body, but there was really strong feedback about how the overall trust needed to be a skills-based board. And so that reflects that feedback that they really need to be people with relevant skills. And I would argue that's a hell of a lot better than what we've got at the moment, where under the existing trust legislation, the Minister of the Day can appoint whomever he or she wants by ministerial fiat without reference to anybody, and there's not those skills-based requirements around membership. There's not those requirements in relation to involve a diversity of voices, including First Nations people. In relation to the community trustee boards as well, there's that idea that they are more representative in nature, and they're selected on their capacity to represent the interests of the park as a whole.
Okay.
And in places like Callan Park, there's no trust at all. So I
Yeah, you guys have had 10 years to sort that out.
well, you can't, and with great
be
respect, you
fair-
can't criticise us on the basis that we're taking action on, and then criticise us on the basis we haven't taken any action. Here's a bill. It's for the Parliament to consider. I think we've got the balance right. Having said that, we're open to sensible and pragmatic and feasible reforms, and that's why we've taken a long time to talk widely, to consult widely, and come up with something that I would submit is a lot better than what we have at present. We can always look to make things better, but also after a period of operation, we can always test and refine legislation. But I think this piece of legislation provides much more robust protections for our existing parks, make sure there's a more strategic focus. There's a real voice within government that's seeking not just to defend the parks, but to expand them and also to involve the community.
Sure, Minister. So I know that there's been some alternative proposals in relation to more of a federated community model rather than the sort of one trust over the top. Is that something you're willing to consider?
Well, I don't necessarily want to create lots more legislation. I think the idea here is rather than creating more and more acts with more and more trusts, I think there's a great strategic benefit in this idea of a city within a park. Sure, we can go down that model of having more bodies to look after local parks, but I actually think that's missing the great strategic opportunity here to link the parks together. And I think the problem has been, while we've had great trusts that have done their very best, their whole nature has been very defensive, and their interests and focus and worldview stops at the fence at the end of the park.
Okay.
When really what we need is to look at the linkages between parks and be more assertive about expanding our parks. We know that we need more, and we need them in the right areas, particularly in the city's west.
We'll come back to that later. I might interrupt you there. Thank you, Minister. I've only got a few minutes left just on this round. Can you just let me know when Comback Stadium was being built, there was an agreement to transfer Wisteria Gardens to Parramatta Park. My understanding is that hasn't occurred yet. Can you tell me where that's up to, please?
I don't know where it's up to, but certainly that is the government's intention, and I'm very, very keen for that to occur because that's an incredible heritage landscape and should definitely be included in Parramatta Park.
Why?
I'm not sure whether the Deputy Secretary can provide an update
Well,
now.
I will try.
Yep, she's nodding.
I can try. Can you hear me?
Oh, much better. Yep. Yes.
Okay. So it's owned by Health, and we're working with Health to arrange for that to be transferred, and those arrangements are being finalised.
Do you have a time frame for that, Miss O'Mara?
I don't. I'll have to take that on notice.
Okay, that's all right. My understanding, I want to talk about Kirkbride at Callan Park. I understand that there's been a successful tender to take over the lease of Kirkbride. Can you tell me where that is up to?
Yeah, that's for a community not-for-profit, I understand. I will ask the Deputy Secretary to provide details.
I'm sorry. I'll have to take that on notice because that's not being managed by my team. It's being managed by the property team of the department. And my understanding is that the process is still underway.
And I understand the Secretary can provide some information.
Yep.
Yes, that's correct. DPI's Development and Transaction Divisions and New South Wales Health are currently assessing responses to the public expression of interest for uses that are consistent with that.
I might be incorrect, but I had thought there was a successful tender. Have you re-tendered it?
The information I've got here is that they're currently assessing responses. I'm happy to take that on notice and get you further
You
information
could
back.
let me know
But,
about that.
I understand that you're correct too, so we'll get you some more details.
Yes, I mean, obviously Kirkbride is the most important building there. The longer it's empty, the worse it is, which is my particular concern.
And which is the whole point of part of this ledge, is to make sure that these heritage buildings are adaptively reused. As the National Trust once told me, you use it or you lose it, and that's why it's so important to make sure that these spaces are used for the benefit of the community and not for profits first, of course.
Minister, I know you're very keen to get this legislation through the Parliament this year, but I also know that there has been requests for a short extension in relation to the exposure draft. Are you willing to contemplate that?
I think, look, I can take that on notice. My inclination is, I think we've had a long period of talking about this. My inclination is to put forward the legislation, and by all means, it can be, we can have conversations as members of Parliament about amendments that people might want to consider. But I don't think the opportunity for consultation is lost just because there's some draft legislation before the House.
That's great. I've got time for one more, I think, have I? Very quickly. Well, I'll ask my annual question, which is how many trees have you planted through your tree targets?
So what I will say is we are on track. In relation to the register, we can probably get that up, but I imagine
You can come back to me a bit later about that, but I am keen to understand how many trees have actually been planted.
Yeah.
And I also will ask the question about just if we know how many of them are still alive.
Yes. Can we get somebody to water them and check them as well?
Okay, we've got the answer, or we'll come back to that.
We'll come back, but what I will say is just really quickly, that's a really good question, and part of my focus is making sure that not only we're planting the trees, but we're actually managing them appropriately, and a lot of the contracts in relation to those have included provisions around the maintenance of trees, particularly as they're establishing when they're young.
Thank you, Minister. Minister, when you were Environment Minister, you supported the nomination to include additional areas in the National Heritage List for the Greater Blue Mountains World Heritage Area. You can recall that?
I recall it.
And then I believe it was last week on Landline, you said that mining in new areas is probably a thing of the past. Can you recall saying that?
I can't recall landline, but there you go. But I'd agree with that assertion.
Okay, so you agree with the assertion that mining in new areas is probably a thing of the past, because you said that, I think, on landline.
I have to be careful here, obviously, because I can't prejudge applications, and certainly mining. I will caution that. I mean, certainly open-cut thermal coal mining, I think, is something that globally we're seeing. A faster contraction from that industry than I think was predicted 10 years ago. But mining is certainly
Excuse me, Mr. Stokes, could you just move the microphone a bit closer to you?
But mining per se, it remains a crucial and growing industry for many of the rare earths, nickel and copper and all these sorts of things, many of which are important in emerging battery technologies and as components of renewable energy as well. So if I made as broad a statement to suggest all mining was moving to be a thing of the past, I certainly wouldn't endorse that without specifying that I think, it depends what we're talking about.
Okay, so what we're talking about specifically is your government has what is called a preliminary regional issues assessment process in place for a new area for coal exploration west of Wallamai National Park near Ralston. There are particular areas called Hawken and Rumka. That is one of them. Another one is Kunguddy. Cool. Where is it? It's another one which I will say in a minute to get it right on Hansard. So these are areas that your government currently is considering. It is before the government now, and I understand it's a cabinet process to consider whether indeed to open up these areas for coal exploration, some of the same areas that you supported being on the National Heritage List as part of the Greater Blue Mountains World Heritage Area. Do you support these areas being opened up for coal exploration?
Firstly, I mean, I stand by my earlier statements in relation to this area. Obviously, I have to be careful in a matter in which I have not by myself a determinative role, but as part of a cabinet a determinative role. I can't talk about the attitudes I'll take in a cabinet discussion, but I can obviously stand by what I've formally put on the public record. But as you appreciate, I can't really speculate terribly much on my opinion in relation to this matter, because it'll have to be a matter for the cabinet to consider, and those deliberations are appropriately confidential.
And just to be clear, those areas that you did support for nomination are the Corricudgee State Forest and Nullo Mountain State Forest, both of which are located in Ganguddy Kilgoola, which is in the area that is potentially going to be open up for coal mine. So,
while it is being assessed,
coal exploration, I should say.
Yeah, and I should stress, while it is being assessed, that is, as you'd appreciate, an appropriate process where there has been public consultation and where the views of the public will have to be considered as part of that process. And I do understand that there was some very strong views from the community. And I will note in an earlier PREA process, for example, that just because there is a PREA process does not in any sense suggest that there is a particular outcome. In fact, the last ones I'm advised, the PREA for exploration of Titan and conventional gas roaches in Bacani Trough north of Broken Hill, Pondy Range Trough northwest of Wilcannia, the Nekaboo Trough north of Ivanhoe, and the Yathong Ivanhoe Trough south of Cobar, resulted in the government deciding not to release these areas. So I just need to say that, yes, they're being assessed. That does not prejudge an outcome.
Okay, I understand that your department produces the preliminary regional the PREA report. I understand that's what your department produces, but it isn't released publicly. Is that your understanding?
I understand it's released once the government has made a decision. Is that okay? I'll refer to the Secretary.
Thank you. Yes, I just got confirmation from Mr. Ray on that.
So,
Yes, because
thank you, Mr. Ray.
it's a cabinet process, it will be released after the process is complete.
Okay, so the cabinet has before it PREA's report as to whether they will PREA's report recommending areas to be released, or we don't even know whether this assessment recommends these areas to be released. The public doesn't even know that yet, correct?
No, but I just want to correct one thing. My understanding is that the relevant board, the advisory board for strategic release, will consider the PREA and then make recommendations to the Minister for Regional New South Wales as to whether the areas should be released for coal exploration. So that is before the cabinet process.
Who's on that advisory board?
I think that's a matter of public record. I'm not sure exactly. I think from memory there is a representative of the department on it, but we can get you that.
We'll take that on notice.
Industry representatives on there? Does that include? Is that just purely departmental and government, or are they outside?
I don't want to. Actually, maybe Mr. Ray might.
Mr. Ray?
Yes, look, I think it's actually, there might be one independent representative, but it's mainly representatives from government, but I will get you the answer on that.
Okay, thank you. Minister, have you personally met with stakeholders concerning the Hawkins or Rumka, potential coal release areas?
Not really recently, but I suspect I would have in the past.
Okay, so you haven't had a briefing on this issue?
Not a separate briefing, no, but for the purposes of budget estimates, yes.
Have you expressed concerns with your knowledge and history of the fact that you in the past have recommended these areas be added to the National Heritage List? Have you expressed your position or told your cabinet, your colleagues, that in fact these areas are worthy of National Heritage listing and you've supported it in the past?
So in relation to the current process, my involvement has not yet been triggered, and I obviously am not at liberty to talk about those matters, but you do know my view in the past, and so I can obviously stand by that.
Okay, thank you very much. We will move to questions from the crossbench. Mr. Justin Field.
Thank you, Chair. G'day, Minister. Welcome. Just on the Hawkins-Rumka release, the entire strategic release process was an outcome that was agreed to in response to previous ICAC findings. The ICAC's recommendations were that this strategic release process should bring forward some of the decision making in order to alleviate the stress in communities of having development proposals hanging around. And it really recommended that that process should look a lot like the major projects process. And of course, agency submissions in that process are made public before a decision is made. Why isn't the PREA made public? Doesn't that go against the ICAC's findings?
I will reflect on that. Well, I'll make a preliminary comment and then go to the Secretary. I mean, this process is largely led out of regional New South Wales, and we, are involved as relevant. So I suspect the answer is probably the question is probably directed toward that portfolio minister, but I will pass over to the Secretary.
Yes, thank you very much, Minister. So the department is aware of community concerns about the transparency of the New South Wales Government strategic framework, and several members of the community have, as you've identified, requested that the department's PREA be made public when it's sent to the advisory body. The department did write to the chair of the advisory body asking it to consider that request, so that's the department's position. The request was denied by the advisory body, and I understand that the department's PREA will be released once it's considered by government, as the minister said, and ultimately further questions really do need to go to the Minister for Regional New South Wales, as he's the relevant minister for the strategic release framework.
So you sent that letter to the chair requesting that they consider. So, Minister, do you think that it should be made public before it's considered by cabinet?
Look, I'm not going to. I'm not going to canvass matters that are outside of my portfolio responsibilities. That really has to be directed to the portfolio.
Minister, I know you are aware of some of the concerns around development at Culburra on the south coast, the West Culburra development in particular. Community residents were absolutely shocked to receive a letter from your department last week indicating that the IPC intended to enter into an agreement with the developer Sealark there to accept their modified development proposal. Do you think it is appropriate for such a controversial development, or do you think it deserves an open public hearing so that the concerns of the community and the merits of this proposal could be canvassed and reported on by a court decision?
Well, I understand that this was the result of a conference under the terms of the Land Environment Court Act on the basis of a court-mandated process. So, at the end of the day, I understand this was a result of the action and the decision of the court. I will pass you to the Secretary to provide further information. And, yeah.
Mr. Ray, could you please provide some further detail?
Section 32.
Yes, Secretary, yes. This, in fact, has arisen as a result of the court action, the merit appeal, that the proponent was entitled to lodge following the decision of the IPC. And this has come out of that conciliation process. And the notification of objectors is an important step in that process to ensure that the community is heard before the court before any final orders are made. But as the Minister said, it's a court authorised process, and we certainly agreed that the community members should have that opportunity, but ultimately it is a matter before the court.
Correct me if I'm wrong, but the IPC were acting on advice from the department that the proposal was acceptable in the first instance. So the department has some sway here, and the letters that went to the community offering them the ability to make further comment, there is no bearing on the court's decision from any submissions made by the community. They were given a week, and there is no process technically available for them under this conciliation process for their concerns to be heard. That's my understanding of the process.
Well, it is the process, Mr. Field, that is run by the court, and obviously the court is well placed to make those determinations, and that is the current method by which the court involves community members when a proposal is potentially going to be approved. Now, I understand, I won't go into the detail, I understand there are a considerable number of changes to the proposal that was before both the department and the LPC. But ultimately, and as part of that court process, it's a rehearing, it's a new consideration of the development application, and if the development application's terms are changed and the development proposal is changed, then the current provisions of make the court the determining body about those things.
But the court won't make a judgment on the merits. The court will rubber stamp the agreement between the IPC and the developer at the recommendation of the planning department. Minister, such a controversial proposal, you know this community and the concerns down there. Do you think it's appropriate for it to be decided in a backroom agreement and not actually heard the full merits in hearings in the court?
Look, I mean, it's difficult for me because I'm not the consent authority here, and there's a range of consent authorities, but between the IPC and, as the Deputy Secretary's pointed out, the applicant was perfectly within their rights to test the views of the IPC in the court. I think it's Section 32 of the Court Act provides for these conciliation conferences. That's the direction of the court. I'm not going to canvass the process of the court. That's really a matter for the Attorney General under the relevant legislation, which is not my legislation.
Nothing you can do. Planning Minister.
Well, no.
Your department thinks this is an acceptable development.
Well, in one sense, I suppose the answer to that is that sometimes communities praise the court, sometimes they condemn the court. My role is to respect the court and to respect its capacity to act independently of government.
Thanks, Minister.
Thanks,
Chair.
Thank you. Questions from Mr. Mark Latham now.
Thanks, Chair. And Minister, is it still the government policy that out of sequence land development should be at no cost to government?
So, as I understood, the now Minister for Health, Minister Hazzard, when he was Planning Minister back in 2011, invited the development community to put forward rezonings that they wanted to focus on, and on the understanding that they could be advanced if they came at no cost to government. I think the lived experience has been that there is cost to government in these processes. While we will always consider applications that are brought before the system, my own preference is I think it's easier and clearer for the community to understand over time where infrastructure is required and facilitates more orderly development if we can work with landowners to identify progressively sequenced land for release. That's not to say we won't entertain developer-led proposals, but strategic planning led by the department, I think ultimately over the long term is preferable. The Secretary may have a view on this as well.
I certainly agree that the challenges of aligning infrastructure with land release would make it infinitely more desirable to understand over time, as the Minister details, where precincts will or land will be released. However, there is always the opportunity for proponents to come out of that process, and sometimes that may end up resulting in very positive development outcomes for community.
So out of all what you've said, generally it's still the policy, if it's out of sequence, it should be at no cost to government.
This is why I think the lived experience is there will always be a cost to the community in relation, to whether it's direct or indirect. You can't provide thousands of new homes or job opportunities without relying on the public purse to support at least some major infrastructure. Of course, all the local infrastructure should be provided at no cost.
Right, the local infrastructure.
Mr. Latham, could you move your microphone closer to you, please?
The local infrastructure should be provided at no cost. Well, that's what the department told Celestino when they first lodged their Sydney Science Park development in October 2019. They said the department advised that delivery of out of sequence would need to be in accordance with the current policy of no cost to government. So what went wrong? How did Celestino end up with the $11 billion rail line with a benefit cost ratio of 0.75 and very low passenger projections, a $200 million Sydney water investment, and also moving the outer Sydney orbital to avoid the Science Park site with additional cost to government if that road and rail line was ever to be constructed. How out of this policy was this billionaire company from chicken meat background, how did they end up winning Lotto?
Well, I can only speak to my involvement in processes, and I can quite confidently say, I've always acted in accordance with advice from the department in relation to these issues. I think the route of the North-South Metro was determined as a process that was kicked off by the city deal process, and I think it's pretty clear that that route goes straight through that area. I'll refer to the Secretary if there's any more detail we can provide, but I suspect the issues on
the orbital was going to go straight through that area too in all the planning documents until the government moved it at additional cost to facilitate the science park. But Minister, given that you were the planning minister that gave them the gateway tick off and then the final rezoning for this Sydney Science Park, you're involved in the Westmead research agreement, which is now totally collapsed, and Minister Hazzard said it expired after 2 years. You were there for the announcement about a STEM school that was supposed to open this year, but of course is invisible and will always be invisible. Do you now look at this Sydney Science Park as a model of how not to do urban development? Because there's been huge government expense here for absolutely no outcome. There's no sign of any science technology jobs ever being delivered. And in fact, in 2 recent applications to your department, the Science Park's trying to walk it back to turn it into just another Western Sydney housing estate.
Yeah, well, I certainly think the vision of an integrated jobs, research, advanced manufacturing hub proximate to Western Sydney Airport is a laudable vision, and ultimately, government will always encourage through appropriate processes additional investment in these sorts of things that provide great opportunity. I mean, one of the things that the government's really focused on is ensuring that we take that there are more jobs developed and not just dormitory suburbs, which is where the premise of your question leads. Ultimately, many of these matters are matters for the investment community as to whether people want to invest in things. I think I'm not quite as what's the word? I'm a little more sanguine about the opportunities over the longer term. I think there's a great deal of excitement about the opportunities of the Aerotropolis, but as we all know, it's going to take many decades for that vision to be realised, and I don't think. I don't think anyone should expect things to happen overnight. It's going to take some time.
Yeah, Western Sydney land developers are always excited, but here we have a proposal that was supposed to deliver over 10,000 jobs in the high-tech science sector. It all sounded wonderful, glossy brochures, half a dozen or more government agreements to do all things from automated taxis to health research to the STEM school. What's the lesson out of this in terms of how the planning model should actually get some form of guaranteed deliverance of these jobs before we get the expenditure of $11 billion for a metro line that will barely be used, $200 million for the water facilities, and moving a major outer Sydney orbital road at additional expense to government to facilitate a science park that's become a ghost park?
Well, ultimately, I think the rezonings are what it is, so it is still rezoned for those purposes that can be achieved over time. So I don't think we should despair that this area will over time be developed, and hopefully for these great purposes for which the current rezoning is there to facilitate. In relation to what the planning system does to ensure that things can be achieved, well, ultimately the planning system is to give people rights to do various things. Ultimately, whether they choose to do them or not is a matter for them. I can say in relation to development applications, if they're not acted upon, they will expire, and a applicant will have to reapply. In relation to rezonings, will they stay in place until they are removed by or changed or upzoned by subsequent government action?
Okay, we'll move to questions from the opposition now. Back to Ms Penny-Sharp.
Quickly, I think now that we can hear Ms O'Mara, I just wanted to go back to that issue around how leases will operate, and that the difference between what will be sort of managed EOI processes and unsolicited proposals.
Yes, Ms. Sharp. Just grab my notes. So essentially what the bill is doing is that where there will be commercial development, that can't extend beyond areas where there are existing business activities or plans of management. And the bill provides additional protections for community in the sense that there need to be plans of management that set up a framework for that, and those plans of management need to be the subject of consultation with community trustee boards. And as the Minister said,
Oh,
No,
we've just
that's all right.
lost
We've gone.
you.
That's okay. We've lost you again, Ms. O'Mara. That's okay. We'll come back. I'll hand over to my
As the
colleague.
Minister
No,
said.
that's okay. It's not your fault. That's fine.
we're just getting a lot of reverb.
No, I can tell. It's fine. I'll let you go at this point.
We spent all our money on bolos.
Yeah,
Me
you
to
go.
go? Minister, I wanted to ask about the fast-tracked assessments. So I understand 101 projects were approved in the 6 tranches. Is that right?
Yes, and I'll also, because the incoming secretary was also the head of the planning delivery unit who was intimately involved in the process, I'll refer some of this to the secretary as well.
Yep.
But yes, that is
That sounds
correct.
right. Yep. How many of those 101 projects commenced within the 6 months that was required for fast-track approval?
Yeah, I think the secretary will be able to get the note up. I know the overwhelming majority have, and that there is a process underway to manage the ones that haven't been able to meet those timelines. But my understanding is the overwhelming majority.
We'll get to that process in a tick. But yeah, if you had a figure.
I'm just grabbing you the exact figure here. Can I just confirm, out of the 101 projects that were assessed, and that I want to make it clear that they were assessed, 98 of those were approved. There's no guarantee just because something is determined that you've got an approval. So just to stress that now, and I'll come back to you shortly. Here we go. 89% of those projects, and I can't quite do the maths there, did proceed to the next stage of development within 6 months. The ones that have not proceeded to the next stage of development, there are a range of reasons, some of which are within our control. They're working with councils to ensure that councils can make DA assessments. Others are developers where financing has fallen over that period of time, or in 1 or 2 instances, it's where land has subsequently been sold for financial reasons. So where materially we have been able to see those approvals translate either into shovel in the ground or a DA in the case of a planning proposal, 89% of those have done. So 14 that haven't translated at this point in time.
And of the 14 that did not meet the requirements for fast-track assessment, I mean, has the approval that the Department of Planning gave them been revoked? Because obviously it was a pretty core requirement of the fast-track approval that commencement was to occur quickly, swiftly. So if that hasn't happened, has your approval been revoked?
The short answer is no. It just is approved in the ordinary process under planning law. And as you would anticipate, this was a response, an appropriate response to what was and continues to be a real challenge for our economy, but particularly at that time. And we were relying on guarantees from those proponents. That is why we had a very careful probative process as part of this, because obviously you are picking and choosing, but we were picking and choosing on the basis of 3 main priorities. The first was number of jobs that could be sustained, the broader public benefits that could be demonstrated, and finally that last bit about timeliness, that the proponents were prepared to provide guarantees that work would begin in the relation of a matter requiring a DA within 6 months, and of a planning proposal that DAs would be submitted within 6 months. In the overwhelming majority of cases, that has transpired, and those guarantees have been honoured. Sadly, in those cases, for a variety of reasons, and I'm happy to particularise those reasons in the on notice, a minority of them were not able to fulfil the guarantees that they provided.
I want to go to one particular example, which was the modification 4 of the East Lakes Shopping Centre, which was approved, I think, in tranche 2. Do you recall meeting with the member for Heffron in relation to that project?
Yeah, I from memory, I met with him on a couple of occasions. He also spoke about it in the House. I think I was there to listen to his
concerns.
His
that
concerns.
the project would not be able to
Yeah.
commence within 6 months.
Yeah,
as you
and
say.
I recall I communicated those concerns to the department, but I'll refer to the secretary in relation to any specific details she can provide in relation to that project.
I might talk to one of my deputy secretaries there, Mr. Whitworth, in relation to the East Lakes proposal. It's a mod. Sorry, Mr. Ray. Yeah.
Sorry. Secretary. So in relation to that particular application, there were 2 sites. There was a north site and a south site, and the modification was to both the north and the south side. The north side was under construction, but could not be completed until the modification was finalised. And so in that particular case, the completion of the north side met the criteria of the fast track assessment program. And I might just say that the determination on the modification did not do anything else other than do a full assessment of both of the changes to both the north and the south side. And indeed, there were lots of benefits from the modification on the north and the south side. Less overshadowing on the park, a range of other measures to deal with concerns about loading docks and various other things. So the assessment was a full one, and it met the criteria because it enabled the completion of the northern side.
I mean, Mr. Ray, I suppose, so it is still your view that that proposal met the requirements for fast track approval, which included commencement within 6 months, even though now in October 2021, more than 16 months later, as was brought to the attention of the minister, and on his evidence, he passed that on to you, there were concerns that would not occur, and in fact, that is exactly what's happened.
So the advice to me at the time was that the project met the requirements of the fast track program because it would enable the completion of the works to the northern side within the 6 months. But I just also want to assure you that ultimately that matter would have been determined anyway, whether it was then or a couple of months later. And there was there was a full assessment of all the issues, and I'm perfectly satisfied that every issue was appropriate to be considered as in the assessment of that site. What was considered, including all the community consultation, and there were considerable benefits for the modification on the surrounding areas compared to what was originally approved by the then Planning Assessment Commission in 2013. So yes, the advice to me was it did meet the requirements, but I'm also confident that the development would have been approved on similar terms, perhaps a couple of months later, if it had not met the criteria.
Well, I mean, that may be the case, but we are talking about its approval under the fast-track assessment process, which required commencement within 6 months. Minister, you were told that there were serious concerns that would not occur. You were also told by the member for Heffron that the applicant was a donor to the Liberal Party. Did you take that into consideration when you passed that correspondence on to the department?
From recollection, I don't recall him saying that. And in any event, how on earth could he be, if he was a developer, how on earth could he be a
By
donor?
the Free Enterprise Foundation.
Well, I wasn't, from the best of my recollection, I wasn't.
So you don't recall the member for Heffron when he told you that there were concerns that the application did not meet the requirements, also alerting you to the fact that
hang on, no, a couple of things. We've just been told by Mr. Ray that the advice of the department was it did meet the criteria for inclusion and the reasons as to why. In relation to the donor issue, I certainly can't recall that. That would have been a material matter I would have passed on, I would have imagined. Having said that, equally, it's not appropriate that I seek to interfere in one of these processes. The concerns that were raised by the member were appropriately passed on, and I think Mr. Ray has answered those concerns.
Were you aware prior to the granting of the consent and your correspondence with the department in relation to the application that Darryl Maguire was acting for the applicant and had been seeking to organise a meeting with the then Premier Berejiklian in relation to it?
No.
Had he sought to meet with you in relation to the project?
No.
I mean, it just seems that there were two pieces of advice information that were received here. One, from the member for Heffron, the local member, that this application would not meet the requirements under fast-track assessment because it would not be able to commence within 6 months, and other advice that the department acted on. And it's not as though we don't know what happened. We do know what happened because it's now 16 months later and it has not commenced. The member for Heffron was in fact correct. So it's just interesting to me how the department came to a completely different conclusion despite being alerted to the fact that there were concerns. And this application was given fast-track approval when it has, as a matter of fact, failed to commence construction within 6 months.
Well, I just think the Deputy Secretaries provide the information that the determination did enable the construction of that north site. So I think he's answered the question as to how it fit within the program, and I think he's answered those questions. But in relation to the other issues you raised, that's news to me.
Just briefly, finally, then on this site, which is one of the 14, I think, that have not, at the end of the day, met the requirements under the fast-track assessment. You've said you're not going to revoke the assessment, the approval that you granted, and you're working through those. Can you give us any more information?
I have no power to revoke an approval or a determination once given. I have no power.
Even though the basis for the approval was that this was fast-tracked assessments to, as you say, get the economy moving, these 14 projects, multi-million-dollar projects, given the fast lane to get activity moving, they've not done that. They failed to meet. I'm sure that they told you that they could, but they didn't, and you're not going to do anything about that.
Well, a couple of things. I mean, the first thing is the whole idea of this program was to fast-track as many assessments as early as possible on the basis that they could generate activity, a lot of jobs activity, and it was wildly successful in achieving that outcome. In fact, the Victorian government sought to emulate pretty much the same process. Over the period we approved, I think, $25 billion worth of investment. They did the same thing and approved about $7 billion. So, sadly, and I share your frustration, obviously when proponents make guarantees, you expect them to be met. But nevertheless, the advice of the department was they met the criteria for inclusion. That went through a process where this was a process that the appropriate integrity bodies were consulted on. There was a probity advisor in relation to the selection of all of the projects, so there was some clear probity rules set up as part of this process. Obviously, we can reflect on the learnings of this process. It was quite novel. We were experimenting because there was a real need to get things moving. Of course, if there are improvements in process in the future, it would be my expectation that the department reflect on those and how we can do better. But I think in total, the program was enormously successful.
And what is the value, both in terms of the job creation and the economic value, for the projects that did not commence?
As I mentioned, I'm more than happy on notice to provide the details of those projects and the reason as to why they did not proceed, and the values attached to those.
Yes, and so just to confirm, Ms Fishburn, you will include information in relation to the job creation and economic value associated with the projects that did not proceed.
We've been very transparent about CIV and jobs attached to each of the programs.
That's right.
So we'll provide that information.
Minister obviously featured a lot of promotion of the jobs and the economic value that was created, so it would be useful to know.
I was very aware that we are prophesying of the future, so it was very much couched in these could enable up to a certain number of jobs or up to a certain number of homes. But remember, as the Secretary has identified, these were fast-tracked for assessment, not for approval. And a number of them were not approved.
I want to move on briefly, probably have to come back to it, to housing affordability. Do you accept your government's completely failed on housing affordability now? Is that something that you can accept now, Minister?
I'm sorry, in the nature of the question, accept failure in terms of?
Providing affordable housing to people who want to get into the market in Sydney.
Do
you not know what housing affordability means?
Order.
Come on, I'm trying to.
Point of order has been taken by
the point of order
the member.
is the obvious one, that it's important to treat witnesses with respect.
Yes.
And while you've been doing very
Public
well, Ms
servants.
Jackson, you've gone over the line just
Thank you. I was just sitting
Well, the
back
Minister
here
can look
thinking how
after himself.
civil everything was at this budget estimate. It's incredible, really. So, but I'll just remind members to treat witnesses with respect at all times, if they possibly can.
Thank you. No, I mean, in one sense, I accept the admonition. The reason I'm sort of struggling in some respect is the concept of affordability is a little bit relative, and it's always, we've got to be very careful with terminology around these things.
You want to go there, Minister?
Relatively bad right now.
Yeah, no, I would accept
Well,
that.
for
How much
people
money
on
you have?
incomes like
I would-
ours, relatively it's not as bad as, say, a nurse or a teacher or an early career firefighter. Relative for those people, I think it's pretty tough to get into the housing market in Sydney. Wouldn't you agree, Minister?
Well, I'll answer your earlier question, and just to say that this is, as you would appreciate, something that is happening in a whole range of housing markets, including Sydney. In fact, we're seeing housing affordability or house prices climbing extensively across the OECD. I think of the 40 developed economies, only 3 are not growing in sort of exponential ways. Places, many similar cities to Sydney, Toronto, Vancouver, even some of the Sunbelt cities in the US are experiencing sort of double-digit increases in value. There's a whole range of reasons as to why that is occurring, some which are in the control of the state, some of which are in the control of the federal government, some are in the control of local governments, and some, frankly, up to international sort of monetary policy more broadly. So I don't think this is really helpfully served by an exercise in seeking to apportion blame, but rather to take responsibility for the levers that we have. In my case, as Planning Minister, the real thing that I can add to the mix is a consistent supply pipeline of well-designed homes fit for purpose in the right areas, and that's the job that the department has. We know that in Sydney, that we require about 40,000 housing approvals a year. Across New South Wales, about 60,000 a year. That's consistent with how we're tracking at the moment. Of course, we're dealing with an historical undersupply that's creating some supply challenges, and we also have supply challenges in different markets. For example, at the moment, I don't think you could describe it as an undersupply inner city apartments in central areas, but we do face undersupplies in regional areas. Greenfield demand certainly has spiked in a way that no one would have anticipated a couple of years ago. So I guess the challenge is a supply pipeline requires infrastructure provision, and the timelines on supply of infrastructure takes a little longer than financial markets move around. And also, when there are stimulus packages, that'll also change people's preferences as well. So all of these things, create some challenges. It's important to reflect on the various roles that we do have, and my role as Planning Minister is to keep that supply pipeline going.
Thank you, Minister. We'll move to questions from the crossbench, starting with Mr. David Shoebridge.
Oh, thanks, Chair. Good afternoon, Minister. Nice to see you.
Likewise.
Minister, what are the additional commercial activities that you're planning to allow in Parklands under the Greater Sydney Parklands Bill? What are the additional commercial activities?
So I would draw you to proposed section 6A in the Callan Park Special Provisions Act 2002, which is Schedule 5 of the exposure draft, and that does talk of additional uses for arts and cultural purposes. I think that's the relevant section, but that outlines the process where there can be leases for
I was
commercial
asking you
activities.
what you intend. You intend what additional commercial activities were you thinking will happen at Callan Park?
Well, I mean, it's really ultimately not up to me, but certainly the sorts of things that listening to the community have spoken about are things like cafes or art galleries, pop-up events like, what was the one that was mentioned the other day?
The Laneway Festival.
Laneway Festival, those sorts
Happened
of...
there.
Yeah.
Happened.
Yeah.
They don't need this bill.
Yeah. Well...
Laneway Festival already happens at Callan Park.
Yep.
Why do we need the bill to have something that's already happened at Callan Park? Is your advice that you need this bill to get laneways at Callan Park?
No, to get things like a cafe that you might see, for example, at Centennial Park. Currently, under the current settings, no one's come along with a proposal to do those sorts of things. I think there'd be some
Deal
great...
with them one at a time.
Yep.
Laneways, we agree that that's already happening at Callan Park. Already happened. You don't need that. You don't need that, do you?
Let's be clear.
You asked me before what sort of commercial activities would we be contemplating at places like Callan Park. Pop-up events would be some of those that could be considered.
We don't need this bill to get laneways at Callan Park because it's already happening.
That you don't want anyway.
It's already happening at Callan Park.
And again, I mentioned events like that. I can't with any specificity, provide you guidance as to whether the current legislation would provide for all those sorts of pop-up opportunities. But the one you mentioned, well, that's happened in the past. I understand you've opposed in the past. Hopefully those sorts of things are things we can see happen in the future.
Well, there's already been cafes at Callan Park, but they have to be operated through a not-for-profit. So they can be part of a not-for-profit's operations. That's already happened at Callan Park. So do you accept you don't need it to have a cafe at Callan Park?
Is there a cafe at Callan Park?
There has in the past.
I don't think there is a cafe at Callan Park.
There has in the past been cafes operated.
But I think you've just made
not-for-profits.
my case for me, Mr. Shoebridge.
How?
Because you've said that there are cafes, there aren't cafes. This is the
No,
point.
I've said
there's
there
a cafe
have
in the
been
past.
cafes operating
So
in the
it went
past through
busted it because it wasn't
not-for-profits.
able to have enough security of tenure that it could maintain operation. These are the
You're saying
sorts
that
of things.
because you know that, Minister?
No, but you're saying that the cafe closed. So I don't know the reason why it closed, but presumably one of the reasons could have been because there wasn't sufficient security of tenure to
probably
sustain
your
the
government
business.
behaved badly towards the not-for-profit, and that's why they had to shut their
I very much
cafe.
doubt that, Mr. Shoebridge.
But
I
we
think
can
the
have
sorts of
cafes.
uses that we want to see are the sorts of uses you see at places like Centennial Park, where there's wild walks, there's wild play, there's all sorts of great opportunities. There are things like sporting activities that may involve some commercial activity. There may be things like cafes or galleries that might involve a measure of commercial activity. But all of those things are based on activating these spaces so people can enjoy them.
You know that there can be a for-profit element of a not-for-profit activity already at Callan Park. So a cafe can be run by a not-for-profit associated with a not-for-profit at Callan Park already. You've already had that advice, haven't you?
No, but the point here, Mr. Shoebridge, is we've got countless buildings of significant heritage value under the current legislation. No one's been able to provide a use for them. They're locked up. They're effectively falling apart because no one's using them. We want to provide the opportunity for small private businesses to provide a service to the public. You know, what's the problem with, you know, providing somewhere where people can have a meal or can look at some artwork or to do all these sorts of great things.
The bill isn't limited to that. The bill opens the door to
Well, you asked me what
activity.
sorts of commercial activities we were talking about, and I've answered your question.
But the bill isn't limited to that list. It's a much broader opportunity to have long-term leases of public land, isn't it?
Well, and longer term leases, and the longer term is to allow the investment in the sorts of heritage upkeep that we know is required there. Of course, government has a role in upkeep and restoration, and we're proving that commitment with a multi-million-dollar investment right now. But we all know that the level of investment required in these structures is enormous, and if there's no use for these buildings, then there's really it's a very hard case to make to put taxpayer money into doing up buildings that are going to be locked up and not allowed for activation to make them better places to visit.
Well, there hasn't been the public investment in these buildings which would make them attractive for not-for-profits to date. So we really can't test it because your government has refused to put the money forward to make them attractive venues for not-for-profits.
Well,
That's the history, isn't it, Minister?
No, I reject that. We're putting in millions more than anyone has put into Callan Park. But the challenge, of course, is that if we under the existing legislation, no one's come up with proposals to use a whole series of these buildings. So, you know, my plea is that we can open them up so the public can use them and enjoy them. This is parkland. It should be there for everyone to enjoy.
The proposal, to be clear, is to open them up to allow private entities to occupy them for a decade or more under private contracts. That's actually your proposal.
To provide services and opportunities consistent with the objects of the Parklands Bill, which is all about activating these spaces, looking after them, ensuring that there are opportunities for people to lead richer lives by enjoying our parklands.
Minister, you pointed out that you wanted opportunities like in Centennial Parklands. That's your starting point, is it? You want something?
Well, no,
like
I was actually thinking of a
Parklands?
wonderful cafe in Centennial Parklands and thinking, why can't there be something like that at Callan Park?
What's wrong with the way Centennial Parklands is currently operating? Why do you want to take away the localised management in Centennial Parkland and put it in this citywide board? What do you see is wrong with Centennial Parklands at the moment?
Well, I think the challenge we have is actually, I think there's a lot that's right about the way the Centennial Park public participation provisions operate, and that's why we've brought Callan Park under the aegis of that legislation in the meantime, where we're working up a broader model to manage, you know, to govern all of these parklands and to find a way in which we can effectively expand them.
Minister, have you gone out and spoken with the community around Centennial Park or around Parramatta Park, and have you heard the level of opposition that they have to their local management of these critical local and regional parks being sucked up into a single citywide board? Have you heard the level of concern they have about the loss of local control, the loss of local engagement?
Well, again, I mean, when you're talking about Callan Park, for example, there is no local control. There is no local engagement.
I was talking to you about Centennial Park and Parramatta Park, Minister. But answer the question. Address the question. Centennial Park and Parramatta Park.
Okay, well, we talk about Centennial Park.
Correct.
You mean the board that is appointed by ministerial fiat? There is, I think, from memory, there is one community representative. Surely we can do better than that, and surely this bill provides a way forward with community trustee boards and with a skills-based board, which was designed on the basis of feedback from the community. They wanted a skills base for the minister to select from, rather than just being some sort of opaque process of direct ministerial appointment.
Well, Minister, you can have a skill-based board and increase the community representation on the board of Centennial Park without abolishing entirely the Centennial Park Trust and having a citywide board.
But Mr. Shoebridge,
Centennial Park, it's a straw person argument you're putting forward.
You know, but the one thing that I do genuinely believe is that Centennial Park, of course, it's important to the community of Woollahra and around the eastern suburbs, but it belongs to all the...
Sydney.
But it belongs to everybody. It doesn't just belong to the people of the East. This is the point, Mr. Shoebridge. And that belongs to the people of all of Sydney. Okay? Of course the locals are important, and of course their views are important, but that doesn't give other people in other parts of Sydney not the right to use these parklands and be interested in them as well.
Minister, you've pointed out that the history would suggest that Parramatta Park has been protected over more than a century. Centennial Park has been protected over more than a century because of the structures that have been put in place, and now you want to abolish them. Do you understand the anxiety that that puts in communities, that the protections going, that have obviously worked to protect them from development, are going with your bill?
I don't agree with the premise of your question. You're saying the protections go. I mean, have you read the bill? The bill is all about putting in stronger protections, about creating a stronger voice for parklands across
citywide
Sydney.
board that takes away all the local engagements.
Well, that's just not what the bill says.
Okay, we'll now move to questions from Mr. Mark Latham. We'll go to you first.
Thank you, Chair. If I could direct a question or two to Mr. Brogden, please, who's online. John, when the budget estimates last convened in March, Adam Searle raised with you some issues about declaration of conflict of interest. In the 7 months since, have you changed the way in which your interests are declared at Landcom?
Thank you, Mr. Latham. Are you hearing me okay?
Yes, I am.
Okay, sorry. We have made a small change, which I think I'm happy to continue following the meeting in terms of the paperwork on it, Mr. Latham.
Does that change mean that instead of declaring your interest down the chain of command, in the instance concerning Peter Brennan and Bradcorp, to your legal and compliance officer, who's subordinate to you as the CEO, you'd now declare it up the proper chain of command to the chairperson of Landcom?
So the original policy required people to declare, as you said. Can you still hear me? Sorry.
Yes, I can.
Yeah, we can. Sorry. Keep going, Mr. Brogden.
Yeah, sorry. Required a declaration of interest to be made to a member of the legal team, or to an executive general manager, or to the head of legal, and that is now an and rather than or, to the best of my memory. As I said, I'll get to the paperwork. And yes, I'm now required, the CEO is now required to, as you said, declare it up the chain.
Oh, so you now only declare to the chairperson of the board?
I missed the beginning of that, sorry.
So you now only declare to the chairperson of the Landcom board?
No, in addition to...
So you'll declare to the chairperson of the board plus the legal and compliance officer?
Correct.
Right, okay. Well, I suppose that resolves a good part of the issue. Mr. Brogden, I'm sure everyone in the Parliament congratulates you on the outstanding work you do at Lifeline as the chair and all the fundraising activities, but I've got to note that one of the reasons you had that declaration concerning Peter Brennan was his role as a donor to Lifeline. Is this a structural conflict of interest where land developers contributing to Lifeline also come across your desk as the CEO of Landcom?
I don't believe so.
Are there other developers other than Peter Brennan who contribute to Lifeline that raise a similar issue?
You'd have to ask Lifeline that issue.
Well, you're the chair of Lifeline, aren't you?
Yes.
So I'm asking you.
Well, point of order, Madam Chair. Point of order, Madam Chair.
Point of order's been taken.
I mean,
Mr. Franklin?
Mr. Brogden is here clearly in his capacity with Landcom and not with Lifeline. It's an inappropriate line of questioning and should be ruled out of order.
I was unfortunately speaking about tech issues just then, so I didn't hear the beginning of the question, but I did hear you say you're the chair of Lifeline. You are correct. He is here as Landcom, not in his position as Lifeline. So I just
I know, but I'm asking about conflicts of interest in his role as the CEO of Landcom on the basis that one was previously declared concerning Peter Brennan Bradcorp, the land that was purchased at Wilton.
Yeah, continue.
Because Peter
Yep.
Brennan had, one of the reasons was that Peter Brennan had donated to Lifeline.
Sure.
Are there other land developers involved with Landcom who donate to Lifeline where you've had to declare conflicts of interest?
Sorry, I'm waiting on the point of order.
I said for the member to continue, Mr. Brogden. So sorry, you're missing the cues, I think, in this room. But that question was in order from
Mr. Latham has narrowed the scope appropriately.
Mr. Latham. Yep, continue. And I just to take this quick minute to say we are trying to address the tech issues during the 15-minute break we will take at 3:30. I am aware of how difficult it is for everybody tuning in. Go, Mr. Latham.
I can only repeat the question I asked earlier, which is, are there other land developers involved with Landcom activities that come across your desk that also donate to Lifeline, raising a conflict of interest similar to the one that you declared with Peter Brennan and the purchase of the land at Wilton?
I refer you to my previous answer.
Well, Chair, I don't think the witness is answering the question there. It's a matter for Lifeline. It's a matter for you as the CEO of Landcom as to whether you've got other conflicts of interest, surely.
But I'm not aware of every donor to Lifeline. Do you expect that the chairman of an organisation to be aware of every donor?
Well, I'd expect that as Peter Brennan went to your fundraising functions and maybe sat on your table, sat at other tables, there as the chair you know who attends and donates. And I'm asking, are there other land developers that you'd normally expect, it's a great charity, who also you have dealings with the Landcom, and do you declare that as a conflict of interest?
I'm not aware at the moment. If you'd like me to take it on notice.
Yeah, if you could take it on notice and get back to us, I think it's a legitimate issue that comes out of the Brennan matter that was raised in March.
Okay, great. Thank you. We'll go to questions from Mr. Field.
Thank you, Chair. Minister, I'd like to talk about Warragamba Dam. Obviously, the EIS is now in the planning system. In a submission to another parliamentary inquiry that's currently being conducted into the integrity of the biodiversity offsets scheme in New South Wales, Ecological Consultants of Australia, New South Wales, or the Ecological Consultants Association, of New South Wales, commented, and this is a quote, "The accredited assessor who produced the BDAR," this was for Warragamba, "was asked to change their assessment by the government, or it was unclear whether this was the government or the company itself, but continuing, to downplay the impacts of the project on biodiversity loss relating to a critically endangered species." They go on to say the consultant in question raised the issue with the department and a private inquiry was launched, but there has been no public statement released and the consultant lost their job. Now, I'm not entirely clear of the veracity of this, but can you confirm, was there any inquiries launched within your department? Are you aware of any inquiries that have been launched by your or other departments, and do you know of any outcomes from that process?
I'll refer you to the Secretary.
Yes, and I'll have to ask Mr. Ray for his advice on this matter.
So, Mr. Field, I'm certainly not aware of those circumstances, but I understand from a report in the newspaper yesterday that there was an inquiry commenced by Environment, Energy and Science, but I've only read what was in the report of The Guardian yesterday. That's all I'm aware.
So EES launched an investigation into these allegations. Is that what you're suggesting, or are you just taking that from the media reporting?
Sorry, Mr. Field, just to be clear, I don't have the media report in front of me, but all I'm saying is I've read that media report. That's the first I've heard of that, and I understand that a spokesperson for EES were quoted in that report, and that's the extent of my understanding.
Okay, Minister, as Cluster Minister,
So this is really a matter for my colleague, the Environment Minister, but we're happy to take on notice and provide any details that might.
That would be great. Given that the the submissions are open, at some point your department will go through and put together an assessment report here. Another media report today has gone into some documents that seem to be related to this particular consultant and the interactions between Water New South Wales, the SMEC, obviously the people engaged to do the work and the consultant. And one of the claims in this article is, or what's put in this article is correspondence, emails between various parties, and it makes the comment that correspondence shows Water New South Wales, which operates the dam, would not accept the ecologist's findings because they did not properly convey the uncertainty with which the agency and its contracted engineering consultant SMEC viewed the depth of impacts. It goes on, regarding a number of plant and animal species, SMEC said that they were altering the phrase that the inundation would likely kill to may adversely impact a proportion of the population. I mean, this dam risks destroying habitat for critically endangered species like the Regent honeyeater. It seems like the biodiversity assessment and the entire EIS, may well be somewhat fraudulent.
Well, my advice is the department is reviewing the EIS and consulting with the relevant regulatory agencies on the proposal, and it's not formed a position yet. I do note that it's also open for public consultation as appropriate. I understand that's also been extended on the basis of feedback from including yourself. I'd encourage the public to be very involved. The history of dam proposals in this country has been that they are enormously, or proposed, pardon me, this is not really a dam proposal, this is a proposal relating to a dam, are enormously controversial, and it is very important that the environmental impact assessment is prepared and presented in a way that public can have confidence in. It would be my expectation that any concerns that are raised are properly investigated, and because and ultimately, it would be my expectation that the department's report is based on accurate advice, and I would want to make sure the department can assure itself that there wasn't any impropriety in how that advice was created.
Thank you.
Thank you, Minister. We'll now break for a 15-minute break and be back at 3:45, hopefully with a slightly better tech system. Thank you. Yeah. Great. All right. We'll proceed to questions from the opposition. Ms Penny-Sharp.
Thank you. Thank you, Minister. At the hearing earlier this week, the Minister for the Environment talked a lot about the need to save the Campbelltown koala population, and he made some statements about being able to guarantee 450 metre wide corridors through that process. Can you tell me how, in planning terms, you're going to be able to achieve that?
Thank you. I'll make an opening statement and then probably pass to Mr Ray in terms of the specifics.
Mr. Wright. Mr. Whitworth.
Mr Whitworth,
for South Sydney.
Apologies. So effectively, a lot of work's been done by the department in terms of preparing, for a significant landscape level conservation plan, the Cumberland Plain Conservation Plan,
which I believe is due at the end of this year.
That's right,
and
I've committed that in estimates, and that will be delivered within that time frame. And the Koala sub-plan is a big part of that plan, and under which, for example, a couple of headlines are, the Georges River Koala Reserve, 1,800 odd hectares.
Sorry, how many did you just say?
I think it's more than 1,800. I can't remember.
Yes, I was going to say, I thought you said 800.
Oh, no,
and I was
no,
about to be very concerned.
And including not just protecting what's already there, but a restoration of 80 hectares over the next 5 years. A series.
Yeah, that's the 200,000 trees.
Yeah, that's right. And then there's a series of fauna underpasses and fencing. But we also got the chief scientist to look forensically at what corridor widths would be required to provide functional corridors between those important north-south connections and provide east-west connections. And my memory was the functional width was assessed as 425 metres, I think was my understanding, but certainly any proponent there, and so, for example, in relation to if any proposal was advanced in relation to Gilead Stage 2, it would have to satisfy the department that it met the requirements of the Chief Scientist's report. But I'll hand you to Mr Whitworth to provide greater specificity and make sure that I clean that up if I've messed it up.
Sorry, we are hearing probably every fourth word.
Sorry.
I heard my name, so I'm assuming that you've thrown to me.
Can you hear me, Mr Whitworth? If I speak right into, all right, I might just restate just where we got to with that, which is the Minister has outlined that there's been work done by the Chief Scientist in relation to the Cumberland Plan and the Koala sub-plan, and he's indicated that the Gilead Stage 2 planning will require wildlife corridors of at least 425 metres, and then he threw to you to give me some more detail about that.
Thank you. Thanks, Ms Sharp. The Minister is quite correct. I do want to clarify, though, that the importance of the Chief Scientist report is about functional corridors, and so I believe that in previous conversations it's been a conversation about whether the corridor is steep or sloping or not. So we're looking for a functional corridor that is flat. The Chief Scientist has set out at least 3 corridors that we can incorporate into the broader land use planning for the Greater Macarthur area, which will cover the Mount Gilead Stage 2. It will cover the South Campbelltown lands and the West Appin lands, and it also provides us with an opportunity to identify those primary corridors along the Nepean and the Georges River as well. We have been working through something called the Technical Assurance Panel with Lend-Lease and with Walker Corporation as the first 2 proponents. And in discussions with those proponents, we have identified the importance of those functional corridors and the importance of ensuring that they meet the width from the Chief Scientist. My understanding is that the Chief Scientist has given us a figure that is an average of 390 metres width, and that's something that we will be working to. But
but we can take on notice the difference between the different widths that people have been
Yes, can I just check
and clear that out because it's something that has created a degree of confusion. The other important element, of course, of those corridors is to make sure that they pass from habitat to habitat and that they can traverse Appin Road without creating danger to the koalas, and also without obviously with ensuring that we can manage the traffic flow. Conversations with Lend Lease, conversations with Transport for New South Wales have been looking at how we can ensure those corridors are those koala corridors are appropriate, that they can be constructed as effectively underpasses so that the koalas have safe passage through. It also gives us the opportunity to specify not just the widths of the corridor, but the uses that will occur within the corridor and the way in which access to those corridors is protected to ensure that you don't get dogs and cats, for example, entering into the corridors. But we're intending to identify that as part of the strategic plan for Greater Macarthur and to also ensure that it's part of the assessment work that goes on for the technical assurance panel.
Thank you very much. That was actually very helpful. Minister, can I just clarify then? So your colleague, the Minister for Environment, suggested that you were getting the advice from the Chief Scientist. So it sounds to me that you've got the advice. Is that actually public?
I'm not sure I can take that on notice.
Yeah, that's fine.
But Minister Keane and I endorse his views. Has been quite clear that for any proposal to be advanced in stage 2, it would have to meet the requirements set out in the Chief Scientist.
And just to be clear, stage 1's approved now, and there are obviously not 450-metre corridors through stage 1.
Well, those decisions were made prior to the Chief Scientist.
So I just wanted, there was some confusion. I'm just trying to sort that out. I've lost someone. Anyway, that's okay. Minister, I just wanted to touch base with the design and place SEP, and just can you just give me a quick update on where that is up to?
So I will provide a few comments and then hand to the Secretary. So effectively, I committed to releasing a draft of the SEP before the end of the year, and we're on track to do that. And we're just refining some of the issues. There was some strong feedback from the development industry, and I suppose in one sense we weren't surprised by that, but we're really keen to work through those issues and come up with a package that improves design quality in New South Wales and also.
Have you got the earphones sort of thing, or the ones that wrap around your ear?
Mr. Brogden.
Wait.
You're not on mute.
Please.
Well, it could have been a lot worse.
We should have just let that go, actually. Continue.
I've lost track. But
no, so the draft. So there'll be a draft SEP. There will be the ability for consultation. I mean, you've just talked about the concerns of developers. There's obviously a lot of concern from environmental groups and others that the intentions are okay, but actually you're removing the kind of minimum standards in terms of the way in which basics and other things would work. Can you just sort of talk me through that? It's very important.
I want to be very clear there, and I had a great meeting with the Total Environment Centre on this issue, and also with the NCC, and I totally understand where their concerns are coming from, in that there is no intention to remove minimum standards. It is rather to provide alternative pathways if a proponent, and this is a frustration of a lot of architects who are saying, look, if we can actually look behind the algorithm and get to greater thermal efficiency or energy efficiency using innovations or different technological approaches or different materials, often we're in a situation where to quote Little Britain, the computer says no because there's this fixed algorithm that they can't look into. So we're saying, great, there's flexibility to provide for innovation, but that's only, but there's still that baseline of performance that's required. But if people have got other ways that they can do something better, we want to incentivise that as well. The challenge with basics in the past is if you meet it, you don't get anything extra for exceeding it. There's no rewards for going further. So that's sort of acted, if you like, as a benchmark rather than a baseline. What we want to set is we want to incentivise better performance, because that, when you get the innovation.
And look, Minister, I think that's you get no disagreement from me about that. But my concern is that that's all well and good for the architects and those actually wanting to, do fancier buildings that will cost a lot of money that many people can't live in, and at the very baselines around, a lot of the development, and, you've said we need 40,000, homes a year and approvals, that there's just not a backing down in relation to that the basics at its most basic, but also whether there's any ability for basics even at that baseline to be dialed up.
Yeah, and that's exactly...
In terms of climate
and that's exactly the intention in the SEP. And please note, I'm not suggesting that, the architects, it's relation to fancier buildings or more expensive buildings. Often some of the work that can be done can actually reduce prices and make it more affordable, and innovation can do that.
I like that in theory, Minister. I'm not seeing that in terms of affordability across the Sydney Basin, to be fair.
Yeah, no, and that's true. And this is always, and this is always a balancing act. You want to drive the best environmental performance you can without making it unaffordable. And some of the concerns of industry is, Rob, that's all well and good, and we support your aims, but you do know that this is going to increase the cost of housing. So we do need to find that middle ground and go as far as reasonable, but without resting on our laurels. I mean, this is one of the paradoxes of housing supply. We need to provide more houses and cheaper houses, of course, without reducing people's standard of living and the quality of buildings. So we've got to, walk and chew gum and do all of these things, which is pretty complex.
Thank you.
Thank you, Minister. While we're talking about housing supply, I want to go back to some of the questions.
Rose, just make sure you, just for the benefit of people on the phone, just really talk into the microphone.
Yep. Want to continue a conversation about housing affordability. So you mentioned previously that New South Wales needs 40,000 homes a year. So that's your goal? That's what you're working towards?
No, what I'm saying is currently what's required for long-term supply is about 40,000 approvals a year. In Sydney, about 60,000 across the state, and that's what we are currently providing. But of course, that doesn't account for historical undersupply that we've got to catch up on.
So how many, for example, how many dwellings were provided in the 2020-2021 financial year?
From the top of my head, I think across New South Wales it was 54,500, something like that, over the last 12 months across New South Wales. And that is about 13% over the 5-year average and about 26% above the 10-year average. So we're tracking well, but I'm not congratulating ourselves. We've still got more to do. It's like painting the Harbour Bridge. You've just got to keep going. You never finish.
Yeah, I mean, you'd be familiar with the intergenerational report that was released this year. I mean, you would also be familiar that in that report, forecasts for housing supply over the next few years dip pretty considerably down to as low as the mid-20s, 25,000 a year. Does that concern you? Have you included?
Yeah, well, I mean, we've been there before. In the past decade, the average has been about 41,000 a year. In the 10 years previous, it was 21,000 a year, and that's part of the problem of catch-up we're dealing with. And so, yeah, there are always challenges, and you always need to find more opportunities to provide supply. But equally, we need to make sure that we provide the infrastructure to match supply, so we're not creating poor quality housing or housing that's not equipped, close to jobs and providing opportunities for people. So you need to do both.
Yeah, I mean, that's great, and we can talk about some of those things, but specifically on supply, as I said, over the next few years, there is a projected dip, quite considerable dip, in the amount of housing supply. Are you doing anything about changing those forecasts? Is that something that...
We're doing a great deal to accelerate supply, and this year alone we've finalised a number of significant rezonings, which are well supported by infrastructure, and we're I'm looking forward to releasing plans for. I think it's around 6,000 new homes in places like Wilton and Rhodes in the near future, and then we've got some big plans in places like Macquarie Park in Frenchs Forest. So there is a big pipeline of supply coming. But remember, it's about the pipeline. It's not just delivering housing and saying it's done. We need to keep going. I'll refer to the Secretary who might have further details in relation to those projections.
Yes, thank you. I'm happy to discuss that. There's some complexity in data when you talk about completions, which the Minister managed to get almost to the number. It's 54,484. The figure that is controlled materially by the department and by local government as the two areas that manage DA approvals is actually around approvals, and the approvals in the same period was 60,684. So what we're seeing is a bit of a disjunct, almost a 10% disconnection between approvals and completions. This has been something that we've tracked over the last 18 months with changes to the market and their interest in brownfields, infields, apartments. I'm happy to go into more detail about the reason for that, but that has accorded its own challenges, with the community being much more interested in greenfields development. And of course, in greenfields, you have associated infrastructure challenges that were not foreseen that the market would completely flip over itself as a consequence of COVID. We have been making sure that we keep our foot on the accelerator in terms of doing the work that we need to do to ensure the supply pipeline. Firstly, we've got two sources of evidence which we didn't have 24 months ago. E-planning actually allows us to track in real time what is happening in the planning system, which is enormously beneficial. The other is the urban development program, which gives a spatial understanding of a Greater Sydney, including where land has been rezoned, where DA has been submitted, DA approved, and then to completion. That's really important data to have because it allows you to unpack why if land has been rezoned, are we not seeing development occurring on it, which means we can then pull the levers that we need to do in terms of infrastructure delivery. In relation to other activities of the department to make sure we keep that supply pipeline going, we've been working very closely with councils to ensure that assessment timelines are delivered more effectively and efficiently, and this is an ongoing program. We're also making sure that there is a mechanism for proponents, agencies, councils and the department to discuss in a neutral space issues that would impact upon supply, and that's delivered through the Planning Delivery Unit. And we've also introduced a number of interagency functions to try and make sure that across the whole of government we've got an understanding about the supply and pipeline, including in both the Greenfields area where we have Greenfields coordination and in the Central River City where we're likely to see a significant population growth, particularly as Parramatta really builds out as the second CBD.
And as a result of all of that work, do you anticipate that there will be an increase in the number of dwellings supplied in the next few years on top of those forecast in the intergenerational report? Because it all sounds great, but the figures are there in your report and it looks like that over the next 5 years. So you're confident that you can boost that?
Would you like me to speak to that?
Yeah. Well, I mean, certainly we have plans to deliver for the housing need that we can project. There is a unit of the department that look forensically, as the Secretary has indicated, into supply pipeline projections. And part of that, and part of the complexity that the Secretary is also speaking to, is the fact that there is quite a deal, I think about 162,000 lots that are already rezoned but are awaiting infrastructure investment before they can be unlocked as well. So it's part of a long progression of pipeline, but the short answer is yes, we are confident we can meet the housing needs of a growing community, and that's a core function of the department. But I'll refer you to the Secretary if she wants to add anything further.
Thank you, Minister. I think you've captured that really effectively. I think that the challenge has been the shift in the apartment market as opposed to people buying into greenfields. I'm no excuses about that. No one would have predicted COVID would have created that type of market shift. We are acutely aware of that and are monitoring it very closely. I think being able to understand the pipeline through the development community as well and what their particular challenges are going to be. Obviously, actually the majority of housing stock in New South Wales is delivered by private industry, and we need to be appreciative of that fact as well. So trying to understand what are the pressure points in the private sector as well, not, of course, to change planning controls or dials, but if it is around infrastructure investment or negotiation with council or mediation through agency outcomes, that's something where the planning department can play a specific role to make sure that we are getting housing stock into New South Wales.
And, and also just to add to that, just looking at the International report, it notes that we'll need to average of 42,000 homes every year. This year, as the Secretary noted, we've built 54,484.
Scroll to page 60, chart 3.2, if you've got it in front of you. There is a big dip right heading our way over the next few years. So, I mean, unless you've got a plan to change that up, we are going to be going down, closer to 20,000 homes a year very soon.
Yeah, and
based on your government's own projections.
Yeah, and some of that obviously is market conditions, but in terms of our role is to provide the opportunities for people to build and opportunities to the market. Obviously, in relation to the actual builds themselves, government has a role in terms of providing a social and affordable housing, but ultimately we provide the opportunities for the market to deliver.
Thank you. We'll go to questions from the crossbench. So I just wonder if anybody, whether Mr. Ray would be able to answer this question actually. The biocertification for stage 1 Gilead, so Southwest Sydney koalas again, heavily relied on the OEH report conserving koalas in Campbelltown and Wallandilly. This is an outlier report really to the previous and subsequent reports on koala corridors around Gilead. So I was wondering who wrote this report, because the report itself is anonymous. It doesn't have an author attributed to it. Mr. Ray, are you aware of who wrote that report?
I can.
Mr. Whitworth.
It's Brett Whitworth here. I can answer that.
Oh, Mr. Whitworth,
Marcus
yes,
is having
please.
trouble.
Yep.
The Koala Plan of Management. So the author of the Koala Plan of Management is Campbelltown Council. Campbelltown Council would have relied on consultants to prepare that report. We can take that on notice. I don't have the name of the consultant, but to hand. But I do know that I do remember that it is someone that had a lot of experience in the field of koalas. But I think it's better to take that on notice for you.
Yeah, I was actually referring to an OEH report, Mr. Whitworth, which is called Conserving Koalas in Campbelltown and Wallandilly. That's the title of the report. It was commissioned. The question is who commissioned the report, who wrote the report, and who requested the report to be written. But that's fine if you wanted to take that on notice. It's specifically an OEH report.
Chair, it is a OEH now Environment, Energy and Science report, and it's best that we take that on notice.
Yeah, that's right. Thank you. It's previously OEH, I think, when it was written. Thank you. I wanted to go to the Kamay Ferry Wharf proposal, Minister. I'm just wondering, firstly, in your role as Minister for Planning and now also Minister for Transport, how do you propose to manage situations of conflict of interest that may arise? Because this is potentially one of those.
Yeah, no, and it's a very good question, and that was my, despite my thrill of picking up another portfolio, as you can imagine, that was the first question that popped in my head. How am I going to manage potential conflicts? So I sought advice from the General Counsel of both Transport and from Planning, and also met with them. They are confident that conflicts can be managed as they arise. They were actually quite sanguine about that, and certainly I have asked for any briefs that come to me to identify any potential conflicts as part of that process, and the answer in most cases, I suspect, will be that when you look at the allocation of the administration of acts, all of the transport acts are allocated to both the Deputy Premier and myself. So in situations where a conflict arises, the Deputy Premier can act in my place as he is charged under under those relevant acts, or he's empowered under those relevant acts as well. But they will be managed on a case-by-case basis as they arise. My understanding is that the Premier, I think, has announced this, is looking to do a broader ministerial reshuffle in the new year, and so it's really just a matter of ensuring that I can keep these agencies doing great reform with a great vision for the government in the meantime.
Okay, I thank you for that. I also understand it's a state significant infrastructure project. Is there consideration on your part then, as you're entitled to do, of course, to refer this project to an independent planning assessment process?
Can I take that on notice? I haven't genuinely, other than being lobbied already by the member for Cronulla, as is his job. I haven't turned my mind to this because nothing has crystallised any action on my part as yet. But that's a good question, and I will answer it on notice.
Okay, just while you're doing that as well, I have been notified that in the planning process, the SEARs, SEARs, are critically important, obviously, to ensure that projects consider and address all issues and impacts, as you know. But in the Kamay Ferry Wharves EIS, many in the community felt that key issues were responded to in a superficial, tokenistic way. They felt that it was a sort of ticking the box exercise, and they wanted to make sure, or in some ways ask, how you can be sure that the department is rigorous in scrutinising this process. So there has been concerns that the consultation process has been less than adequate.
Yeah, and I fully understand that and appreciate that, and my action in relation to that will be to pass those concerns on through the secretary, so that we can make sure that the environmental that the assessment of the project scrutinises whether the issues identified in the SEARs have been appropriately addressed.
Okay, thank you. I now wanted to turn to what is a large and growing volume of Scope 1 and Scope 2 emissions from new coal and gas projects in New South Wales, and just wanting to firstly ask whether there is a government policy in this regard that all Scope 1 and Scope 2 emissions from particularly new coal and gas projects can be offset if they can't be avoided or mitigated. Is there such a policy?
I will take part of that on notice. What I will do, though, is point you to clause 14 of the mining state environmental planning policy that contains the relevant matters of consideration in relation to Scope 1 and downstream emissions. But also, I will point you to a piece of work that the department is currently doing, which is effectively creating a consolidated, integrated set of planning principles that will guide all consent authorities and, where appropriate, all planning authorities and, where appropriate, consent authorities in their decision making under the Act. This is learned from similar process being conducted in the United Kingdom and also in Queensland. The United Kingdom, it's called the National Planning Policies Framework, where they've effectively got a comprehensive set of principles that guide how plans are made. Now, I was, as you'd expect, concerned when a recent Auditor General report, as well as recent litigation in the Land Environment Court, the Bushfire Survivors and EPA case, indicated that the government needed to do more in relation to duties around anthropogenic emissions, and so I've asked for those issues to be addressed in those planning principles so that we can have some clear principle-led policies around how such matters are to be considered. I have had separate conversations with experts in this area, looking as you are intimating into the cumulative impact of planning decisions. This is a challenge in a whole range of areas, whether it's residential density with more traffic going on an existing road, but also in terms of atmospheric emissions as well. Is this issue of atmospheric emissions, and so the principles will help to address this issue.
Okay, all right.
No, I will also take it on notice to see if there's
Yes.
any other policy.
Okay, excellent. Thank you. Wanted to turn to the Narrabri gas project. I understand that Santos Gas is preparing to lodge its first modification of consent for the Narrabri gas project. This is just a year after approval. I also understand that that Santos Gas has not completed the minimum requirements under its 2020 approval. People are telling me that this is the community is expected to be a major modification, not minimal, yet it obviously will, at this stage, will not have the scrutiny of the Independent Planning Commission just over a year ago. Firstly, I just wanted to check whether you are aware that there is whether this modification and potential modification has been discussed, whether any of your officials are aware that this is being requested.
Well, the best thing I can do is refer you to the officials in relation to that. I will also note there's been a recent Land Environment Court decision in relation to modifications, which has significantly tightened rules around modifications. That modifications, particularly to conditions, can only be entertained if they truly relate to the fundamental substance of the approval in the first place. But I'll refer you to the officials in relation to their understanding of discussions today.
Thank you. Mr. Ray, are you able to provide any further context?
Mr. Ray, do you have something on mute? Maybe the phone, I think, where you're dialing through on now? He's having issue. Mr. Ray, is that what?
We're having issues.
Yeah, okay, that
First time.
will have to be... Oh, hello, you there?
Are you there? Can you hear me?
Yes, we can. Perfect.
Okay. Yes, it's been an interesting experience, Chair.
The modification
with the reverb, which I still have on the phone. But anyway,
yes.
I'll have to take that one on notice. I don't have that information about discussions in relation to a modification in front of me, so I'll have to take the question about whether there have been discussions with officials. I'll take that on notice.
Okay, all right. Thank you very much, Mr. Ray. We'll move to questions from the opposition. Mr. Field? Sorry, the crossbench.
Thank you, Chair. Minister, just at the end of my last session, you indicated, I think, I don't want to put words in the mouth, so I might let you just restate it, that any impropriety in terms of the preparation of the EIS, and we were talking about the biodiversity impact assessment in particular, you would look into, or you'd expect your department to look into as part of the assessment process. Can you just elaborate on how they would do that?
Well, fundamentally, that is a matter for the department, but certainly if there are any concerns in relation to the effectiveness of advice or the truthfulness of advice, it would be my expectation that a proper assessment would scrutinise that, and if claims are being made, then it would be my expectation that they would be investigated, and that particularly on a project as significant as this one, one of the fundamental points of the planning system is so that planning decisions are legitimate in the eyes of the public, because the public can have confidence in them. And if there are concerns about the truthfulness of evidence in a planning process, well, they need to be thoroughly investigated, and the department needs to satisfy itself that the information it is relying on to make an assessment is accurate. And if there are concerns, well, then that should influence their assessment. But obviously that's a matter for them.
Minister, you will no doubt be familiar, because I wrote to you about it, and I'm sure you were briefed on the evidence before the parliamentary inquiry that I'm chairing. There were concerns raised by Commonwealth and state officials, various departments, about the adequacy of the EIS and also the degree to which it complied with the requirements of the SEARS. I would note that in particular with regards to offsets, the SEARS make quite clear that the EIS should provide a description of any offsets proposed and details of the offset package to compensate for significant residual impacts. The EIS is largely silent on the requirements of offsets, where the offsets might be delivered, the cost of the offset. Certainly the package, as suggested by the SEARS, is not defined in the EIS. How was it allowed to go out for public consultation without that information?
Well, I can I can take part of that on notice, but certainly I think part of the answer to your question is in the question. In other words, you raise very valid questions that the assessing officers should take into account in preparing their assessment report. Very fundamentally, the EAS needs to demonstrate adequacy in terms of its capacity to answer the issues raised in the SEARS, and if it doesn't do so, then it's unlikely to receive a positive assessment. But I say that without seeking to prejudge that at all. That is ultimately a matter for the assessment report. I might just make as a general observation. If an EIS doesn't do what the SEARS ask it to do, well, then that would make it difficult for an assessment to suggest it's capable of being approved.
Now, I don't want to play you off against Minister Ayres here, but yesterday in budget estimates, when I asked him similar questions, the suggestion that he put back was that we couldn't really do that because until we know the outcome of the planning assessment, we're not sure how much offsets we'll need to provide, and once we've got that, we'll be able to go out there and cost them and look at. That's not the way the planning system works, is it?
Well, as you'd expect, I'm not going to engage in that. I wasn't party to those to what Minister Ayres said. But what I would say is that these are matters for the assessment, and it's not appropriate that I seek to intervene in those matters. But my expectation is that the assessment is rigorous, and that the assessment that through that assessment, the assessing officers are satisfied that the information that they have is accurate, and is also fulsome. And when I say that, I mean in the more modern sense of the word. That is, it's complete, and that they have sufficient information to make a determination on.
The costs of the offset are not suggested in the EIS. It's fundamental to the cost of the project, and therefore consideration of its against various options. The Minister seemed to suggest all that will be dealt with in the business case. But the business case doesn't get tested through the planning process, and it doesn't go out for public consultation and feedback. Do you think the business case, if information is going to be left in there, left for that process, that should be part of the open, public, transparent assessment for this project?
Well, it may be the case, and appropriately, that business cases will influence investment decisions, but they don't influence planning decisions.
Okay, Minister. Thank you.
Thank you. Questions from Mr. Mark Latham now.
Thank you, Chair. And to Ms Fishburn, could I ask, coming into this new position, and congratulations, are you a believer in the traditional principle of a non-political public service?
Yes, I'm a full and frank and fearless public servant.
Right. You might have noticed that I've publicly articulated a number of concerns from DPI employees about your predecessor, Mr Betts.
Mark, can you just pull your,
Well,
just so everyone can hear you who's on the call?
Yeah, it's almost a COVID test that's getting that close to me.
It's actually the direction, Mark, if you just...
Is it?
I think so.
What
Thanks.
things?
Thanks, Ben.
You want it that way? Okay.
It's a double vaxxed mic.
Good. Can I just read out one DPI staff correspondence that's been sent to me that I think is quite indicative of the series of correspondence I've received. It reads as follows in part. It's a lot of criticism of Jim Betts, of course, but I think this part sums it up. As a DPI employee at management level, I can confirm that many staff now live in fear of saying a wrong word that might end our career. Respect is stated as a core value at DPI, but respect is a one-way street at DPI now. The culture at DPI now is if you disagree with Jim's views on cultural social issues, you must be racist or sexist or homophobic, etc., etc. So this is not really building an inclusive, genuinely caring work culture, is it?
I can't speak to that particular matter. I haven't seen that piece of correspondence. I can speak to the DPI values of respect and inclusivity and kindness, and they're certainly values that I will continue to embody in the organisation.
Do you think the best way of developing diversity in any workplace like this is to stay out of politics? Because if you lean too far one way on political and cultural programs in the workplace, there'll be people in a diverse set of attitudes who don't agree, resent that, and end up feeling like they're living in fear of losing their job because they say something wrong, in this case something politically incorrect?
I believe diversity means respecting a variety of opinions, but it also means allowing people to come to the workplace as their authentic selves.
Do you think it tipped too far one way under Mr Betts?
I don't have an opinion on that.
Given that Mr Betts has been sacked, I'd say, because he ran too many political indoctrination programs in Depot, and I mean his departing email made that very clear. No disrespect to the Greens, but he sounded more like a Green MLC than a public servant. Do you think, given the fact he was sacked, it's time to remove the programs that caused the reason for his sacking?
Well, I'm going to object on a number of bases. One is that Jim Betts was so far not a Greens activist.
Well,
but secondly,
like
but more fundamentally, it's asking for an opinion of a public servant, and that is
no,
inappropriate.
he's been sacked. He's gone. Yeah. And I'm articulating a number of concerns.
Order. A point of order has been called, Mr Latham. If we could just hear...
These are concerns outlined by public servants about the work culture.
Sorry, to the point of order, it hasn't been ruled on yet.
That's right. It hasn't been ruled on. I was just hearing Mr Shoebridge, who hadn't finished his point of order. So if we could just hear him finish.
Regardless of the perceived genesis of it, what Mr Latham is doing is asking for an opinion of a public servant, and that's out of order.
Yes, I'll remind Mr Latham to please keep your questions to public servants, not in relation to their opinion, but to, of course, the work that they are undertaking within the department. They are here as government officials and they're not here to proffer their opinion.
Well, I'm articulating concerns of employees of Depot saying they're living in fear. And I'm asking Ms Fishburn, what will you do to eliminate the environment of living in fear that clearly was created by your predecessor?
I don't necessarily accept the premise of that. I will demonstrate leadership that attunes to the Depot values, which is around inclusivity, diversity and kindness.
Okay, thank you. Thank you. We now move to questions from the opposition. It's Mrs Rose Jackson.
Thanks, Chair. So it was good discussion about housing supply. Thank you for that, Minister. But as you have stated many times, the housing affordability crisis is caused by more than just supply. First off, do you accept that housing affordability is at crisis point in Sydney?
Not just in Sydney. So yeah, I accept the premise.
Sydney. Do you accept that there is a housing affordability crisis in Sydney?
I think, well, no, let's not start with Sydney. I think it's actually, it's more broad than that. But certainly in relation to purchasing, I think, I mean, you'd have to be, not here to not notice the huge increases in property prices that we have seen. Rentals, the increases have been more modest, but that's not the case in regional New South Wales, where we are seeing very, very low vacancy rates. So it really depends about where you're talking, whether it's Sydney, whether it's the regions, or which part of Sydney you're talking about. But I do think in some sections of the market, we are seeing, affordability at extraordinarily worrying levels. And so, yeah, broadly, I accept the premise of your question, but just recognise it's different in different areas.
Sure, but to be specific, do you accept that the ability for working people who live in Sydney to afford to purchase property is at crisis points?
Yeah, I think I agree with that. I think, when you look back to the 1950s, for example, I think 2 or 3 times an average income, and in those days many households were at one income, you could afford a house that was considered more of a commodity. Sometime in the 80s or 90s, it moved to being an investment vehicle, and since that's happened, we've seen a rapid acceleration in property prices. Of course, the challenge here is, of course, people and recognising the majority of people in this market either own or in the process of purchasing their property. They don't want to see the value of their properties decline for obvious reasons, and that's not a good public policy outcome, but we also need to make sure that we don't leave people behind. That's going to involve more intervention, in my view, than simply leaving it to the market.
And do you accept that the extent to which ownership in the market is concentrated amongst certain demographics, namely age groups, that there is a substantial and concerning differential in terms of the number of people who own properties or
and my views on this subject are reasonably well known, and I believe that certainly the state needs to do its bit, and we've spoken about housing supply, but there are also tax levers that are very useful to look at here, and I would certainly encourage the federal government to look at those tax levers and see how they can be used to get the great public policy outcomes that we want to see, which is effectively, of course, we want a system where investors can buy multiple houses, of course, but before we get there, let's just ensure that we have a system where everyone can afford one house before we start getting people multiple houses.
When was the last time you spoke to the Federal Treasurer about your views on federal tax settings in relation to housing?
I wish I had a direct line to the Federal Treasurer, but sadly I don't.
Never.
Well, let's just let him answer the question.
That's not what I said at all.
Indeed.
That's not what I said at all. They're your words, not mine. And appropriately, at my level, I speak, as you'd expect, to my counterpart, the Minister for Cities, as well as, and I was involved in setting up a ministerial forum in relation to planning. The last time we spoke about these matters, I think, was, if my memory serves me right, last Friday or the Friday before. But I've certainly also been in correspondence with the Federal Housing Minister, Mr Sukar, in relation to tax changes that we believe would be really helpful to get a particular style of housing built to rent off the ground. We've made significant changes here in New South Wales, but to make it feasible for the investment and development community, we really need some tax changes at a federal level. So we are engaging at a very detailed level with the federal government, but I don't do this in trying to blame anyone else. I accept that as a state, we have levers that we control, and in my case as Planning Minister, that supply, and that is a core focus of what we're doing in the department.
So at that meeting a week or so ago with your state and federal counterparts, you reiterated your view that the federal government needed to change its tax settings in order to make housing more affordable?
We did talk about tax settings, yes.
And what was the response from the federal government?
It was a free-flowing discussion, but I'm very aware that the federal government, and another example of engagement is the federal government has a task force in relation to housing supply, and that we have been engaged in that process. We did discuss that, and I gave some views in relation to tax policy and some productive, I felt constructive suggestions of things that we could do to work together to make sure that we had a cohesive response. And I shouldn't leave local councils out of this as well. Local councils have a big part to play as well.
One of the things that has also been raised by yourself and others is monetary policy and the impact of monetary policy on housing affordability. Is it the New South Wales government's position that the Reserve Bank should raise interest rates to bring house prices under control?
The New South Wales government doesn't control the Reserve Bank.
I'm aware of that, but you yourself have raised monetary policy as having an impact on housing affordability. The new Treasurer on Insiders, I think it was a few days ago, referred to the pressure of low interest rates on housing prices, on increasing housing prices. So do you have a position in relation to what the Reserve Bank should do, accepting that you don't control it, but you've introduced this topic into the conversation?
Well, I don't think it's just me that's introduced this topic.
But you're the minister.
Broadly, but I think it's broadly by a range of commentators. I think it's well understood that monetary policy has an impact. But I don't presume to be the Reserve Bank governor, and I don't presume to tell that person how to do their job. And it's very easy to have opinions on matters you don't control.
Exactly what you've done. Exactly what you've done.
No, you're asking me if I have a position on what the Reserve Bank should do. I'm merely pointing out that it is one of the levers that can be looked at, but what I have said is my focus is on the lever that I control. But I'm also making the point that that by itself may be necessary, but by itself not sufficient to help resolve this problem. In relation, but I am prepared to offer a bit more of an opinion here, just to say that monetary policy is more complex than just housing prices alone. there are a whole range of reasons as to why interest rates are low in the current environment, and there are some good reasons for that. Now, I don't pretend to be an economist, but I understand these issues from a planning perspective, and I understand also their complexity. But I also realise that we need to all look at the levers we have at our disposal, and my focus will be on the one that I have, that is under my statutory control, and that's the planning system.
A couple of stakeholders, a number of stakeholders, in fact, have said that increasing housing supply should be the number one priority for the department. Is that something that you would accept?
Well, I think there's a whole range of issues that we need to look at, but I wouldn't leave it at that. I think supply. We also need to make sure that we supply houses in the right area, supported by the right infrastructure, and also as a decent standard, so that people can have confidence and live in well-designed homes. So it's not just supply, it's supply of what? That's a diversity of dwelling types and tenures to meet the needs of the market, and also to provide a decent standard of living for ordinary people.
Do you accept, following on from the point that you just made, do you accept that growth is not occurring fairly across Sydney at present? That the burden of growth is being felt more particularly in some areas, particularly Western and Southwestern Sydney, and that other areas of Sydney are not experiencing nearly as much growth?
I'd start with, I don't categorise growth as necessarily a burden. I think can be some great benefits of growth. And I think
that growth does impose a burden on local communities.
Yeah, but I don't think it needs to. I think this is part of the point. If it's well supported by infrastructure, the experience in the past is we had, for example, Rouse Hill was developed without any rail connections, for example. And so providing that connection later came at additional expense and meant that those communities were car dependent from the get-go, and we had to retrofit that infrastructure. But if you get the planning right and you provide the parks and the open spaces and the public transport and the jobs closer to home, growth doesn't need to be seen.
Is that what we're doing now?
Growth doesn't need to be seen as a burden. And I think the thing that I'm excited about is actually promoting growth that makes people's lives better, and that people aren't fearful of in terms of congestion or poor quality housing or those sorts of things. And I understand why communities can be concerned about growth, because there are plenty of examples from the past where growth has not been a good thing, but I think that what we need to, our vision is for good growth that makes people's lives better.
And that's a great vision, but you've been in government for 10 years, and do you accept that at present the impact of increased housing supply and the pressure that does put on local communities and local infrastructure is not being fairly distributed across Sydney? Do you accept that?
Well, it's distributed. No, I don't accept that, because it's distributed according to the plans put forward by the Greater Sydney Commission, which is a body that is constituted, including representatives of local councils, to determine where housing can be supported based on the capacity of different areas. And so, effectively, what we are seeking to do is what Peter Culthorpe's vision was of transport-oriented development, and that is where there are significant investments in new or upgraded public transport or even private transport. They're the sorts of opportunities where you can put greater density, and in other areas where there may not be significant public investment in these sorts of things, well, clearly there's not the same opportunity. I also make the point that the nature of where the market prefers to go, and as Ms Fishman has already, or the Secretary has already given evidence that we are seeing that preferences are moving in a way that we didn't anticipate from more inner city locations to greenfield locations, partly as a result of the pandemic and people wanting more open space. That was, and so in one sense, we need to provide the opportunities respectful of where people want to live as well. And in many cases, that is increasingly in greenfield locations. But having said that, we're still making plenty of provision for opportunities in more inner city areas. I mean, I point to the rezoning of St Leonard's as an example. We're looking at a significant rezoning around Macquarie Park, and for the very obvious reason that there is 2 new metro stations in that location. There's a university, there's a lot of jobs in Innovation District, so they're the sorts of areas where we want to focus new housing.
And so, despite the fact that over the next 2 decades, Parramatta's population, for example, is set to increase by 200,000, Camden 227,000, the Northern Beaches 31,000, Mossman 1,000. You don't think that that's unfair at all, or will have any impact in terms of
I think the opportunity. I think
the lived experience of people, say, in Camden and their access to schools and hospitals versus the lived experience of people in Mossman?
Well, I take Mossman, and I see the distinction you're seeking to draw there. But I'd also point to the fact that, as far as I recall, where I think there is an environmental education centre being delivered in Mossman, but I think from memory that's the only new school, whereas in the electorate and district of Camden, there's a host of new schools being provided in that community, and that's on the basis that that's where the growth is occurring. And I think you're characterising housing as a burden, and I think if it's properly supported by appropriate infrastructure, it can be a great benefit. You can actually have great restored environments and great opportunities for people to live in great communities. That's the challenge. And I think if you're thinking that Sydney is like some sort of, the environment is all exactly the same and there should be exactly the same number of houses on every square inch of the city, I don't think cities work like that.
We might come back to this, but I'm running out of time. I wanted to ask in relation to the short-term rental
accommodation
arrangements that have been put in place. My understanding is that the registration of short-term rental accommodation is required to be completed by the 1st of November. Yep. And that is obviously imminent, and that a number and the tens of thousands of potential short-term rental properties are not registered. Is this going to throw people's holiday plans into complete chaos?
Well, I mean, my first response, as you expect, is to tell anyone who's listening to this that go and get registered. It takes 5 to 10 minutes. Yeah. I mean, fundamentally, I accept that short-term rental accommodation has been a largely deregulated industry, but I think it's appropriate in the public interest that we do have a register, and I think that's been well established. We've given an extra 6 months for people to meet their obligations, which, when you look around the world, are actually very minimal obligations. And again, given it's a very short process, my encouragement would be before this hearing is out, people can register their properties.
Okay, good. So anyone listening online, go and register. But let's, shockingly, Minister, that may not be that many people. And so there is potentially tens of thousands of citizens who are desperate to take a holiday after the lockdown that we've had. They want to go and feel regional New South Wales, and they have booked. Unfortunately, the owner of the property is not registered. My understanding is that there are potentially tens of thousands that have not, and 1st of November is around the corner. What are you going to do to ensure that tens of thousands of people's holiday plans are not thrown into complete disarray because those unregistered properties are forced off the platforms?
So I've provided my answer to that question, but I'll refer to the Secretary.
Yes, thank you. Putting aside the Minister's hope that many, many people are watching today, I can advise that as of the 22nd of October, more than 19,000 short-term rental accommodation dwellings have been registered on the register. The department's also started an advertising campaign. We're not just putting faith in estimates. And more importantly, I think, is working with the main providers to make sure people are aware of their obligations to register and make sure their properties meet the fire safety requirements. So we're being very proactive in getting the message out.
19th. How many do you estimate there are short-term rental accommodation?
I'll have to take that on.
Yeah, I mean, I think it's going to be a bit more than that, and so your answer, Minister, is they just have to register, and that's the end of the...
It's a very minimal obligation, and when you consider the obligations on operators of hotels and so forth, this is effectively, I can't imagine you suggesting that they shouldn't be registered and shouldn't meet fire safety obligations.
No, I'm not suggesting
it is an obligation of owners who want to generate income in this way. It has been well known, and the platforms are well aware of their obligations, and we've worked cooperatively with them to ensure that the code of conduct that they participate in developing, and which the register is tied to, that those minimal compliance requirements requirements are met.
Yeah, I mean,
B&B admitted to having 137,000.
yeah, I am not, just to be clear, I'm not opposed to the idea that owners would be required to register, but I am concerned for families who just want to get away for a few weeks and through no fault of their own have booked at a property where the owner hasn't registered and that their plans are going to be thrown into complete disarray and they're going to be really disappointed that they can't take that holiday and there's no provision being made for them.
Look, I've already acted to provide additional time this concern was raised. We have acted to provide additional time for people to meet their obligations. But as you'd expect, when someone is offering a service, quite appropriately, they should meet minimal obligations. And some of this relates to safety for the patrons who are seeking these bookings. The bigger concern that I have, and of course everyone wants to take a holiday, but in the back of my mind, the thing that I'm really concerned about is that these premises, that we have some assurances that they are all safe and meeting fire safety obligations. I think that's even a more important concern.
Yep, I hope so. One quick question about the, because I'm going to run out of time, in relation to the press release you put out in relation to infrastructure contributions. Good to see that you want to engage in relation to the detail there, including with local government, but concerns have been raised that because the exhibition period closes on the 10th of December and local government elections are on the 4th of December, that really most councils are heading into caretaker mode and that there isn't a real opportunity for them to meaningfully engage in that process at this time. Is that something that you'd be willing to consider?
Look, obviously the lockdown affected the local government election deadline, and this legislation was. And these reforms were expecting the council elections to be held in September. So obviously we want to make sure that councils have every opportunity to work with us. I'm meeting with the Local Government and Shires Association, for example. I think there have been 126 meetings that the department has held in relation to this with councils and other stakeholders. In relation to the closing date for submissions, I might refer you to the Secretary if there's any update that can be provided. But fundamentally, of course, we want to work together. The whole point of solving this problem is to be collaborative.
Thank you very much. So a few things to address in that. Firstly, there is nothing that prevents a council from making a submission during caretaker period of council. They permitted to do that. So recognising that, we have sent out a letter to council general managers just a few hours ago under my signature. My apologies there, Minister, advising them that this will be a two-step process, acknowledging that council elections occur on December 4th. The department will be seeking a technical submission from council officers. There will then be the opportunity when the new term of council commences for a formal submission to be made by council. Now that's not a requirement. That is for councils themselves to choose whether they wish to take up that option. Noting that the council election is on December 4 and likely to be called around December 21st. Councils actually will need to meet around mid-January, and if they move into a normal cycle, you're looking at probably mid-February for submissions to come in. So there are two opportunities. The technical submission allows us to get on and do our work as a department, but we do acknowledge that the input of elected officials is always a valuable thing to get, and we've provided that opportunity.
Thank you. Questions on the crossbench, Mr. David Shoebridge.
Yeah. So what's the second deadline, Ms. Fishburn? Can I say that's a welcome development, but what is that second deadline going to be?
I need to get...
I've got something here, sorry. It
Finally got the letter, have you?
Elected councils have until the week after their first general meeting in February to make their submission.
Yeah.
All right.
So noting councils don't have a fixed date of their council meeting, it gives them the time to submit.
That's a welcome development. You should send more letters without reference, Ms. Fishburn. It's a good development.
It is on the approval of the Minister.
Okay.
Thank you,
You got a
Mr.
general nod
Shoebridge.
beforehand.
Yep.
Okay, good. Minister, have you now released the modelling about the impact on income to both the state government and to councils consequent upon the implementation of the infrastructure contribution reforms?
Yeah, so this was something that was requested by this committee when I appeared before, and I agreed that we would release all of the information that was germane. In relation to the specifics, I'll refer you to Mr. Ray.
Yep.
If he can hear us.
Yes, sorry.
Excellent.
He keeps changing his technology. This may be the best.
It may be.
Oh.
I've still got an echo.
Right. I'm interested to see what you wear next, though, Mr. Ray.
Well, I haven't been changing my costume, Mr. I don't know what you are saying. The technology is not me.
I'll send you a photo.
So there obviously we have released a number of bits of information and modelling. One of the things that has been released is the modelling now done by IPART in relation to the new rate peg. That information has been released. We've additionally released further modelling in relation to various proposals, including land development contributions. We've got some scenarios there. We've also got some work supporting the new rates for 712, and obviously, as you can imagine, the effect of the reforms varies between councils because each council has its own set of contributions plans, and it also has its own rate structure, and some of those are particularly idiosyncratic, and we will be working through further modelling during the exhibition period.
Mr. Ray, have you released the modelling that shows what the likely positive income effect to the New South Wales government will be as a result of the infrastructure contributions bill being passed, and what the likely negative impact will be on local councils? Have you released that modelling?
Well, the modelling that was done by the Productivity Commissioner and was done through CIE, that modelling has been released.
Well, what's the likely economic cost to councils? How much are they going to lose as a result of the infrastructure contributions bill going through, Mr. Ray?
Well, the modelling provided by the Productivity Commissioner, I think, let me just find that.
I'm not interested in unrelated other measures, just as a result of the infrastructure contributions bill.
Let me So, as to the whole package.
Yeah, but I wasn't asking about the package, just as a result of the infrastructure contributions bill.
Yeah, so the Productivity Commissioner had said that he expected that council contributions revenue would reduce by about 117 million over 20 years.
And what is it likely that the state government revenue would increase by?
For
the bill.
I don't quite have that figure. So what I can say is that we've obviously made some changes to the proposals that were before the Productivity Commissioner.
Yes. Yep.
In relation, as we always said we would listen to stakeholders, and so we brought forward proposals to increase the 712 rates, the proposed 712 rates in certain parts of.
Mr. Ray, just given we have limited time, could you on notice provide what you understand now the collective financial impact will be on councils?
Thank you, Mr. Shoebridge. We'll make sure we clarify the difference between the council contributions in 712s, 711s and the new regional infrastructure contribution scheme, which I think is where you're travelling.
Correct.
So let us make sure we get you the correct information for that.
Thanks. Minister, have you read the Ombudsman's report that was handed down on the 19th of October under Section 31 of the Ombudsman's Act about the recruitment of a senior executive in DPE?
No, I haven't read the report. I've read the media reports around the report, and I've been briefed on it. And given that it relates to matters at an operational level in the department, I think it's appropriate I provide to the Secretary, although I would note that neither the Secretary or myself were in those positions at that time.
Ms Fishburn, the Ombudsman found that your department misled ICAC and repeatedly broke the law in this engagement. Who's been held to account for that?
Thank you, Mr Shoebridge. Firstly, may I clarify, and the Minister has alluded to it, in 2017-2018, DPI did not exist as a department. The Ombudsman's report refers to the previous iteration of the planning environment. I'm not in any way disputing your question, I'm just clarifying. We do, of course, thank the Ombudsman for completing the investigation and issuing the findings into the 17-18 matter, and I'm looking forward to the New South Wales Public Service Commissioner's review of it. We have, since that period of time, as DPI, as the cluster as it now stands, reviewed and rewritten all procurement policies and guidelines since the time of this procurement in question. You'll note, Mr Shoebridge, that was noted by Paul Miller in his findings when he said, and I would directly quote, the Department of Planning, Industry and Environment, DPI, which has taken over the functions of the former DPE, has agreed to implement all the recommendations on the report.
Ms Fishburn, I'm asking who's been held to account. On the face of it, repeated intentional breaking of the law to get around the public service requirements about recruitment, to get around the controls on procurement. Who's been held to account?
This is a historical matter from 2017-18. It's before my time. It's before my predecessor's time. I'm happy to take on notice your question and to provide further advice back, but this Ombudsman's report has only just come out recently, and as you're aware, I'm very new into the chair.
Well, have you sought a detailed report upon whether or not any of the officers who engaged in this conduct, in breach of the law, misleading ICAC, are they still employed?
What point of order, Madam Chair?
A point of order has been taken, Mr Franklin.
Madam Chair, the witness has made it very clear that she's taken the question on notice, that she's very new in this role, and on all matters surrounding this issue, that she needs to come up to speed and that she will provide an appropriate and detailed response on she's taken the matter on notice.
Sure, I'll just, on the point of order, just remind, we'll just note that, yes, the witness has agreed to take it on notice. If the member has a different question, proceed.
The different question. Yep. I won't repeat the question, I'm sure you remember it, Ms Fishburn.
I'll certainly remember the question, Mr Shoebridge.
Yeah, so are you going to take that on notice as well? Have you sought a report about whether or not the people who are engaged in misleading ICAC and repeatedly breaching the law are still employed in your department?
My understanding, Mr Shoebridge, is that they're not employed. However, I will take that on notice, and I've been reluctant to fall back on the fact that I am very, very new in the job, but in this instance I will. May I finish, please? My absolute priority was ensuring that our procurement practices now, our policies and guidelines that are in DPI now, noticing that the activities were the old DPE, my absolute number one priority was getting assurance that we have reviewed and rewritten all of those policies in accordance with the guidelines and the recommendations in the report. That's been my number one priority, not a staffing witch hunt. So I
don't think it's a witch hunt to find people who have misled ICAC and breached the law. That's actually just due diligence, Ms Fishburn. It's hardly a witch hunt.
I've taken it on notice.
You don't call that a witch hunt.
Thank
because
you.
It's your job.
My understanding, thank you, and I've taken it on notice, and I've said I appreciate that it is my job, but I've told you what my priorities is. It's been my understanding that there is no one currently employed by the department, but I don't want to mislead you, so I've taken that on notice, and I will come back with a further answer.
Okay, that's your time. Mr Shoebridge, going to Mr Pearson.
Thank you very much, Chair. Minister, I have a message for you from 9 Indigenous elders whom I met with last Sunday. And I think you might be already aware of this, but what their concerns are, and they said to me, just ask that bloke Rob Stokes whether he can help us out or not. So you got the drift. You're going to be meeting them, and I think you have met some already. But it's in relation to the 1,618 remains of Indigenous people that have been brought back to Australia from overseas in the Australian Museum. And we can only just imagine what those people actually went through. We have one example of Tambo Tambo, who was returned to Queensland, Palm Island, after he was in the Barnum and he and his family were in the Barnum and Bailey Circus as freaks and etc. So finally he made it back, and there was a ceremony in 1994 in Palm Island. So the question is would the minister be willing to engage with them, and obviously where it cuts across other ministries and local government, to actually have these remains taken out of boxes in a museum, in some dark room, and placed into a grave, and there to be a burial ceremony for whatever can be worked out with the Indigenous elders' advice, to public places in and around Sydney. What is your view on that?
The short answer is, of course. I mean, and I have had a couple of meetings on issues like this. Of course, these matters need to be dealt with very sensitively, yes, and ensuring that everyone who has a voice is heard. The issue here is, I suppose, who is speaking for all of the deceased, and making sure that those views are heard and represented. So there are challenges, but I think that's a really good example of how we can engage in practical reconciliation. It is abhorrent that these remains are in storage in a museum. That I find that personally repellent and horrifying, and we need to resolve it, and I'm happy to be involved in that. Obviously, it will cut across different portfolios, but to the extent that it's appropriate for me to be involved, the answer is, of course, yes.
And have you been involved at all with any local councils in relation to this? Has that been part of it?
No, I've met with a group who have indicated that they would like to see some memorials built on public land, and very keen to work with them to secure that. I guess the challenge is making sure that that we are identifying and respectfully dealing with everyone who is a descendant of the peoples whose remains are in storage. So there is a level of complexity to this, as you'd appreciate, but it's definitely an issue that needs to be resolved.
The elders were keen for 70-ton sandstone blocks to be used as the tombstone above.
Oh yes, so we're speaking about. I didn't know exactly who you're speaking of, and yes, these are the ones.
I don't know how large that is, to be honest, but I think it's too large.
They've been talking about various memorial stones, and it's an amazing vision, and really keen to work with them to achieve it. There, as you would appreciate, some complexity. It's a matter actually I spoke with the former secretary on, and haven't had an opportunity to brief the new secretary, who officially starts her appointment on Monday. But on your prompting, I will have that conversation.
You'd be aware of the memorial that's going to be placed at Bondi for the people, for the gay and transgender people who were murdered.
Yes.
That's actually that's on public land on that path there. That's actually been very sensitively dealt with between your department and the local government. You're aware of that?
Yes, I am. Yeah. And I think a similar vision to create a more just and inclusive society that heals past wrongs, I think is a wonderful vision for us to aspire to.
Yeah. Thank you. Thank you very much.
Thank you. I'll just kick on with some remaining questions in this time. Ingleside Place, the draft Ingleside Place strategy, you're very aware of that, Minister, and I know you've been lobbied from lots of people in your community. I understand that you undertook to find documents that the New South Wales RFS and New South Wales Fire and Rescue and Police gave in terms of the documents that they used to assess the risk of developing this area with the 980 new dwellings, and you undertook to the community to find those documents, which they have been requesting for some time. How have you gone in your search for those documents?
The only challenge with with the premise of your question was it presupposes their existence. So what I suggested is, of course, all relevant documentation will be provided, and I undertook to investigate whether there was any documentation that had not been provided and ensure that it has. So that was my expectation of the department to do that. I understand that's been done, and I'll refer you to the Secretary just to for an update.
I will refer to Mr Whitworth for advice on this matter.
Mr Whitworth?
Thank you, Acting Secretary. Thank you, Chair. Yes, we've the community. The request has been for the sign-off from RSS and New South Wales Police and other emergency services. That sign-off came more in the form of the agreement to, or the emails and so on that said yes, this report's okay to go, or were through the participation in the project control group that oversaw the process in which the reports were prepared. We did go back, and there was some degree of concern that the reports themselves should stand as the documents that are prepared by government. But I think the more important thing is that there have been a number of submissions made and raising concern about the evacuation process, which gives us the opportunity to go back to council, to go back and sit down with the emergency services providers and say, this is what the community had raised, these are the concerns, can you help us understand, resolve them, and look at those issues. I think it's important to reflect that we want to take a precautionary approach with Ingleside. We want to ensure that we are not putting people in danger. This was a vastly reduced proposal from the original proposal. The original proposal was 3,400 dwellings. This proposal was a reduction to 980 dwellings, which reflects on the fact that the value of community engagement is that we hear, we listen, and we act. And the community has raised a number of issues that we want to explore and continue to look at, and make sure that the council is at the table with us to help do that and ensure that. I think one of the lessons that we also learned is that we'll ensure that we can get. Okay.
Yeah, it's all good. I just wanted to try and squeeze in one more question. This is in relation to Whitehaven Coal's Maules Creek coal mine. I understand they have put in a modification which will allow them to, for approval, which will allow them to bury thousands of massive off-the-road industrial tyres. Within this modification request, which I have before me, they say that the recycling of waste heavy vehicle tyres is not considered to be feasible or viable. However, I just wanted to make sure, Minister, that you are aware that the Tyre Stewardship Australia has just begun a product stewardship scheme which would see the recycling of these tyres. And in fact, the New South Wales EPA and the Tyre Stewardship Australia both envisage a window of 2 years from now in which a tyre reprocessing facility can be built in the Namoy region. This is important because a number of these coal mines, these coal companies are putting modification requests in to be able to bury thousands of these tyres with all the subsequent potential environmental impacts. But we have just had, which is exciting, this approval for a tyre reprocessing recycling facility in that region. Will you commit to having a look personally at this modification request now that you know this information, this development has occurred?
Yes, and it will be my expectation that the department will take that into account in the assessment, and I will also speak personally to the relevant assessment officers and make sure that they're aware of that. And that sounds like an exciting opportunity, and of course we should take advantage of it.
Excellent. That is good. David, do you have Mr. Shubridge?
Thanks, Chair. Minister, thank you for getting the synthetic turf study done. That's been a good thing. But one of the clear recommendations in it was to change the process so that councils are required to put a DA in for any synthetic turf proposal, so the community gets a say.
Yep.
Now you can do that with the flick of a pen. will you do it? Will you do it this afternoon?
We are doing two things concurrently. First, we've asked the Chief Scientist and Engineer to look at what are better alternatives in relation to synthetic grass and or fields, and the other thing is the Office of Sport and Planning are doing a piece of work on what guidelines should be generated and the expectations of councils in relation to that, and I will get advice on that. I imagine I think we gave them a few months to get that work done.
The guideline will be completed in the first half of 2022.
Yeah, but Minister, neither of that addresses the DA issue. That's solely in your patch. Will you provide will you provide a response?
I'm not going to preempt the work that the department and the Office of Sport are doing. So the answer is no, I won't preempt it. But I will take their advice in relation to what those guidelines should be, and whether that would include, for example, requirements around DA. The reason I'm hedging a bit here is I'm aware that there are costs associated with these things, and so I think it's appropriate to before we go to the heavy-handed regulation, let's see what we can do through guidelines.
Okay, great. I think we've just we'll go to the opposition probably just for one last question.
Minister.
884,640 procured
that's
or
procured.
Is that my trees?
I anticipated that.
618,177 trees planted. 266,463 procured.
How many
You haven't told me how to dead.
I thought
That's okay. I've actually got. Sorry, it's okay if you take that notice. That would be great. I've actually got a question, which is, look, Minister, Aerotropolis, hundreds of thousands of people moving into Western Sydney over this period of time. You've spoken a lot today about housing, massive amounts of housing going in. I just wanted to ask you how comfortable you are with the fact that you've reduced the amount of land set aside in the Aerotropolis for parks, playgrounds, sporting fields and those things by 42% from the original plan.
So, look, I mean, there I'm keen to get as much parkland as possible, but I've got to militate that against also recognising that there are a lot of landowners who are affected there, some of whom, and you can contact or listen to the Community Commissioner's report into these issues. We do have to deal compassionately. A number of these people are not wealthy by any means, and we needed to be mindful of their circumstance and situation. I'm satisfied that the plan that is currently on exhibition enables 95% of all future residents to be within, or dwellings, to be within a 5-minute walk of green open space, which is a lot better than many areas of Sydney. But we also need to not just require access to parkland, but also in terms of the DCP requirements around tree coverage and those sorts of things to make sure that these streets themselves are leafy and cool. So it's access to parkland, but also about plantings as well. And those zonings now relate to areas that are within that are flood affected, flood islands, as well as biodiversity lands as well.
All right.
15 minutes.
I won't.
Yeah. Or Lou Amato. Surely he's got. Come on, Lou. Now's your time.
Lou, do you mind if I take the lead on this, Lou? Okay, great. Madam Chair, no, it'll come as a shock that we are very comfortable with both the breadth and depth of the Minister's answers today, and he's answered all of our questions.
Oh, thank you, Ben. Nice way to wrap up. Thank you, Minister. Thank you, government officials, for attending today. Very sorry for the technical issues. We have been going a lot better than that usually, so not sure what happened today. Normally things are very smooth. Of course, the Secretariat will be in touch in terms of any of the questions you have agreed to take on notice and about any supplementary questions we, of course, will submit. So thanks very much and enjoy your evening.
Thank you.
Thank you.
Thank you.